Olga Dmytrenko, lawyer of the European Court of Human Rights, that is going to speak about access to court, challenges and rules. I just hate this mic. Good morning, everybody. Finally, it's my turn to speak, and I am really happy that I am speaking in the morning because my presentation and the subject matters that I'm going to cover has more questions than answers, so I'm looking forward to a fruitful discussion after the presentation. Yesterday, the day was really intense and you were tired at the end of the day, so today everybody is fresh and full of energy. Since you're here and coped with the icy roads, then you can do that. Okay. I'm going to speak about access to justice, to courts, challenges, and rules. Let me start by thanking the organizers for a chance to participate in the forum. When I was offered to come over here and I was offered to choose the subject matter to speak about, I decided to focus on access to court, but this issue is very broad. You can cover various aspects here, and you can spend 3 days discussing access to court. So I decided, therefore, to start by asking the question, what is the objective that we have, and what are the challenges that people have when the government provides to its citizens access to court? Since we are discussing this issue, given the European Convention of Human Rights and given the Ukrainian cases there, I would like to base that on my personal experience of a judge. I have been a judge for 17 years, and the last 4 years I am working for the Department of Preliminary Consideration of the cases, and I'm reporting the cases under Article 24 that provides for the following. If the sole judge considers the case, the judge can make services of the rapporteur that is appointed by the court. As to Ukrainian cases, every year I see around 2/3 of the cases, that's new cases. And let me just go back to what Judge Danishevska said, that the European Court made the decision, and after that the Supreme Court starts receiving the applications. That's the decisions when the applicants can appeal the cases. The time was extended for that. A European court found violation there because this. I didn't speak about reopening of the proceedings. I said there was no notification to court. So it was the appeal submitted, but the notification was not served on. Okay, sorry. Well, thank you for the clarification, but well, you have to understand that I take it the way I know these cases. I think you remember the situation that was before 2014 when pensioners who were still working submitted their request to recalculate their pensions. The pension fund refused that. They went to the court of the first instance. the court satisfied their grant, and then they went to the Court of Appeal, and normally the Court of Appeal renewed the time and then revoked the decisions. We had many cases like that. I think at the moment they make around 100 of the cases that are leftovers, but as soon as the judgment is made, they go back to the national level. So I wouldn't say that it is pinpoint, but it looks like, okay, so that's national level, the European Court, the national level again. So we don't receive these cases anymore. We start receiving new groups of cases. And it doesn't really matter what was the decision delivered on these groups of cases. Well, getting back to access to court or justice, I would take court and justice in square brackets, because access to justice is a wider notion in comparison with access to court. That's an interesting subject matter to speak about. We need to define first, and I don't claim to be able to provide correct and universal definition, but the definition of access to justice that I like is borrowed from the UN documents. That's in particular ability of an individual to go and receive a protection remedy through formal or informal justice in compliance with the human rights standards. Informal justice, that's an interesting element here. Again, different UN documents state that 80% of disputes in many countries are resolved in the course of informal justice. Informal justice can include mediation, and this could be interesting for Ukraine. This is the subject matter that would be interesting to discuss, in particular whether pre-trial mediation or mediation instead of adjudication, whether that's an effective remedy for the countries with high corruption risks, where the mediation can be one of the means to resolve the issue. In many countries, it's done to decrease the workload on the courts, because one of the challenges that we are facing is limited resources. That's one of the reasons for searching for alternative means, and mediation is one of them. There are naturally a lot more other advantages that mediation has. Access to justice, one element of it is formal and informal. Formal contains definition of access to court. It's very interesting to see how the definition was evolving. It's not an old concept that we have, as some might think. Day in a court initially meant a possibility to participate in the case pending before the court to present parties' arguments. European Court for the first have looked into the question whether the Article 6 guarantees the right to go to court, if it provided for the guarantees in the case that is already adjudicated. It was 1975 Calder versus UK case, a classical case that is often mentioned when talking about access to court. In that judgment, the definition is given in the following manner. That's providing for the opportunity of hearing and resolving the case on civil rights and duties. civil rights and duties. That's a separate issue for the discussion when we speak about the convention. So some public disputes are excluded from the scope of Article 6, but the case law is changing, so that makes it another really broad issue for the discussion. The possibility of considering and resolving the case, well, based on my experience, and you can check for the numbers, for the statistics, Article 6 is the champion in terms of the applications and violations that were found by court. Access to court and guarantees of a fair trial, and that's also covered by Article 6, and that's reasonable length, execution of judgment, issues related to the revocation of the final judgment. The court considered all of them through the prism of access to court, because access to court loses every sense if the decision or judgment delivered by court is not executed, or if the judgment is nowhere to be seen. So there are many cases filed against Ukraine dealing with the violation of reasonable time frame or length of proceedings. So that's a serious problem. We know about this, but there are less cases on that we receive in the court in comparison with the previous times. It seems to me that the failure to execute the judgments, while it was on the cases when miners were not paid their salaries, then there was a group of cases that was dealing with the recalculation of the pensions. New cases that we receive today deal with the non-execution of the judgments that were delivered ages ago. So that's the remains of the wave of pension payments and other social benefits. Again, I don't claim to provide you exhaustive list of these cases. Maybe on Monday, when I'm back in the office, the situation will be different. But that's what it is at the moment. Given all the importance of the access to court, the court keeps talking that it's not an absolute right. And here we start seeing questions as to challenges the government faces when providing for access to court. When preparing for the forum, I decided to categorize the challenges and restrictions into two groups. The first group, that's a group of challenges that are not linked to the will of a state. In Ukraine, this could be lost control over some part of the territory and military activities going on there. We can discuss whether that's outside control or not, but to me, that's an external aspect. And here we need to talk about positive obligations of the state to provide, irrespectively or given the circumstances, to provide for the access to court. Cases against Ukraine are numerous. As to the case law, one of the cases that is often referred in Ukrainian judgment, that's Hamidov versus Russia, dealing with military activities in Chechnya. As to Ukraine, that's cases Klebikov versus Ukraine and Cesar et al. Versus Ukraine. In both cases, there was no violation found, but they are interesting because the court analyzed whether the government did its best to provide for access to court. And again, that's my personal opinion, but the Klebik case is problematic to me. Well, I took another look at it and realized that the court analyzed the situation on the basis of the arguments provided by the applicant. If you look at the other judgments of the court, very often a court is proactive and says, okay, you could have done this, here you could have done that. If it is Article 2.3 procedural duties, the court might say, well, this person was not questioned, this was not done, this is missing, and that's why we found procedural aspects under Article 3. In this case, it was based on the scenes that were exclusively offered by the applicant. Applicant was convicted, and the case was in the appeal instance, military activities were launched, and there were the following options. So his appeal has never been considered, and the case turned out to be lost, and the options here are whether to start a new investigation and start the case from scratch, or go to third parties, international organizations that have access to the territory, and try this channel to find materials of the case, or consider the case based on what is available. All these options seem to be the ones that cannot be implemented, and the court said the government did everything it could, exhausted all opportunities, because none of them would work. So my subjective opinion, maybe you have some comments on that too, is how we should pursue this. And I am not saying that it is by violation or anything like that, but given all the circumstances, can we speak about positive applications then? You've heard all the stories how people, while living in the occupied territories, the judges were saying, you know, we were shelled, but we closed the door and we had the hearing, so it was me and the parties that the parties said, okay, what are we going to do? We are being shelled. So when we are talking about evacuation and life-threatening situations, so well, I think it's incomparable with the materials of the case. This angle, though, was overlooked by the court, namely, there was a chance to evacuate the archives from the occupied territory. So that's just my thinking out aloud. It seems to me that, well, not everything was done with respect to protection of people. Nothing to say about papers. Well, applicants on the occupied territories claim that they don't have access to court, and the courts stopped functioning. So the applicant said it's difficult to go over to the government-controlled territory, but they didn't detailize that. So the court assessed existing legislation and the situation, and found that the state fulfilled its positive obligations and created conditions for the applicant to go to a court, because the courts were relocated to government-controlled territory. So it's interesting to say what the circumstances should be to say that the government failed to fulfill its positive obligations. For instance, people say that, well, okay, so that's the person who is bedridden, seriously sick. They don't have access to anything. The question here is how can they how can they find the lawyer who would issue this letter of proxy? So sometimes attorneys tell me, okay, we use Skype to talk to people to figure out if the person is alive or exists. I don't know how you do that. I am not claiming to be the person who knows all these details, but these are quite problematic issues, and we have several complaints when applicants are in the state different from Cesar Etel case, who said that while we are sick and it's difficult for us to go to government-controlled territory, their state is much more difficult. So when we talk about access to court, so the applicant has some duties to be able to exercise this right. So that's a challenge for the Ukrainian society that we have at the moment when it comes to access to court. Another group that's limited resources. Limited resources, irrespective of the country, whether it's Ukraine or France, that's a very acute issue. And we heard this example mentioned several times yesterday. It's a very good example when we talk about opening of the case and hearings when there is no need to do that, and that's objective decision. So the higher we go in the hierarchy of courts, the stronger limitations could be. We are not talking about hearing the case on the merits at the first instance, that's cassation instance, and the court repeats that the convention doesn't guarantee cassation in civil cases, but if the cassation exists, then all the guarantees of the right to a fair trial should be observed, in particular access to court. But the government has larger margin of appreciation, and the requirements might be stricter. A larger group of cases that we have now, that's cases that were filed when national legislation had this notion of low-value cases or de minimis cases. So in one of the cases against Ukraine, the court received the complaint that the applicant couldn't go to the appeal instance. The claim was worth 600 hryvnia. I think the court could have up the case with larger value of claim. Right now, we keep receiving many complaints where applicants state that the claim was not considered based on low value, and they refer to Azykovska case. In the Zhukovska case, it was the claim worth 600 hryvnia. In some other applications that we receive, it could be 300,000 or 150,000 claim. An interesting question here is at what stage the court can find this case low-value case. There are many applications where applicants claim that neither the first or second instance found the case low-value case, and whether there will be any separate ruling on that, that's the question that we have. But when referring to Article 19, the court said that since the claim in one case was 700,000, and when we speak about a low-value case as the case that does not exceed the 100 minimum subsistence level, and we have low complexity cases that were found by court as the minimus case. The case here shouldn't exceed 500 subsistence minimum. So the court interprets these rules in the following manner. If the value of the claim is less than 500 subsistence minimum, then it is a low-value case, and the court may find it a low-value case at any stage of the hearing.
So for Ukrainian, 100 subsistence minimums is 175,000, or if it is 500, it is almost 2 million. Therefore, 100 state that for people, these sums are not significant. Okay, it depends, as they say, but anyway, the state has its own discretion power, and we do not have see here any problems, and the cases are unacceptable. But for example, recently the applicant sent a letter to us stating how could you refer to Azykovsky case. The amount of her claim is 600 hryvnias. If I were her, I would probably even dare to refer to the Supreme Court. With him, the sum was about 700,000. So these are the complaints we get now, and probably we can discuss even some other problems here. There is also another group, and I will briefly mention it because each aspect actually is a wide aspect of questions. So we talk about certain resources beyond the state's action, like natural disaster, etc. And the second group is about procedural rules established by the state. The goal is to preserve some other guarantees of a fair trial. This is what is called good administration of justice, high quality justice. Here we are talking about the time frames, legal certainty issues, procedural requirements, how you pay the court fee. Talking about these types of cases, they have always existed, and we still get these cases. And the interesting question we face quite recently in relation to this group of cases is that the applicant submits some documents and states that he is underfunded, he has low income, and therefore he should be exempted from paying the court fee. So what kind of documents the applicant should submit in order to confirm poor financial condition? And in some resolution it is stated that what you have provided is not enough. Some resolutions do not address this question at all. So for us, this issue is open. Well, there are certain commitments on the part of the applicant, but still the person should clearly understand what are the rules of the course, how you should recourse to the court, what are the terms, what are the requirements, etc. With respect to Ukraine, the cases have always existed and they exist now because there are all the time there were issues related to the interpretation by the court of this or that procedural norm. And finally, there is another category of cases related to obligatory requirement of judicial representative. There was the one case against Ukraine, and probably this will be the final point in my presentation. And in the judgment, it was stated, as in other judgments related to the access to justice, the fact that we discuss these cases, and what is important is to discuss proportionality. So the restrictions should be corresponding to the goal. And in the case I'm referring to, the court stated that the requirement of our legal representative, the lawyer, for example, the goal of this requirement is good administration of justice, and taking into account the limited resources of the state, this will probably expedite the court proceedings. Well, it is debatable whether the lawyer can influence the time frame for consideration of the case, but the final goal is good administration of justice. At the same time, the state should have some guarantees. For example, a person should have access to free legal aid, and in this judgment it was stated So it is important both at the legislative level and at the executive level to remember that the right to access to justice is not absolute right, and if it is not an absolute right, we have to weigh the circumstances. For example, if there is a military conflict, uh, and for example, there are cases when the applicant cannot appeal to the cassation court because the amount of the claim is not very big. So there are certain exceptional circumstances that should be taken into account. I'm not going to exceed my time limit. The topic really is interesting, but still there should be a final point here. Thank you for your attention. Thank you, dear colleagues. We have two questions. Alexei will be the first one, and then one more participant. Thank you, Ms. Dmitrenko. Very informative report. And actually, I wanted to raise one of the questions, and you have raised it yourself, by the way. Here we have the head of the Supreme Court. Here we have the Secretary of the Grand Chamber. So the issue of access to the cassation appeal, a civil case, 350,000 hryvnias. First instance court had general proceedings. The Court of Appeal also considered the case in general proceedings. So we lodge the cassation complaint, and we are rejected because the case is found insignificant. 350,000 hryvnias probably for a judge is not significant sum, but for an applicant who is a pensioner who has low income, 350,000 hryvnias, which is a debt of the enterprise in response to this person, is really an important point. And therefore, I face this problem in the cassation court, both in civil and administrative jurisdiction. Therefore, these issues should be raised. If first instance court and the Court of Appeals considered the case as general proceedings, why the cassation court rejected the case. So this definitely is wrong. So thank you very much for raising this issue. Probably I will respond first and then you. Probably I will make you sad. The applicant had the first instance court, the second, the Court of Appeal, and if the provisions of the law can be interpreted in this way, so probably here the interpretation is the case of low complexity, which can be found as insignificant case. Do I understand it correctly? Dear colleague, probably I will specify the problem or the issue you have just raised. One can hardly state that this is insignificant sum for the Supreme Court or for the judge of the Supreme Court. I think this is a bit incorrect hint. The insignificance criteria are established by the law. If you follow legislative initiatives, you'll probably see that the Supreme Council of Ukraine is trying to raise the sum up to 1 million, at least in commercial cases. And it means that small entrepreneurs and medium entrepreneurs probably won't be able to recourse to the Supreme Court. It is not the matter of the court. It is established by the law. It means by the Parliament of Ukraine. So really, we have lots of discussions in social networks, and these people are not experts, and they actually accuse the Supreme Court of rejecting the cases. But the same should not be done by the experts. We understand that the Supreme Court is actually accused of not using the filters too much, and therefore we are overloaded with cases. This is one of the accusations we often hear. So evaluating the legislative initiatives, we have made our decision, and we have addressed the Supreme Council of Ukraine, the Parliament of Ukraine, not to raise the amount of such claims, because the first instance and the second instance courts are not in very good condition. I mean, they are understaffed. We still have not enough trust on the part of the society to the first and second instance courts. So there is no need to set additional barriers in relation to access to justice. So we consider it should not be the case, but still, if we work and if we follow the strategy which was established for us, we sooner or later we come to the point when the Supreme Court is considering cases only of major issues which are really very significant for the society. At the current stage, the court is on your side, but still we have to follow the legislation and we have to meet the requirements of the procedural codes of Ukraine. Well, the Supreme Court of the U.S. is something I really admire. This is my personal opinion. I think this is the model for us. People will all the time be unsatisfied. People have access to the Supreme Court of Ukraine, but if the judgment is not in their favor, they later refer to the European Court on Human Rights. So if we have certain legislative provisions and if the provisions were accepted, then the European Court probably should follow them. So probably I would refer not to Ajakovska's case, but another case where the sum of the claim was a bit higher. For somebody, even 600 hryvnias is quite a substantive sum of money. And now I give the floor to Pavlo Pushkar for a very brief comment. There is a special manual on admissibility of applications, and there is that criteria of insignificant damage. It is really vague from the viewpoint of claims of the applicant. For example, when the claims are about non-pecuniary damages, and in this case, as a rule, the European Court rejects or dismisses such cases following this criteria. For example, there was a case of Portuguese Football Association, I do not remember the name. The amount of the claim was about 300,000 euros. So you can see that not in all the cases the European Court on Human Rights takes a decision in favor of the applicant by admitting the application. Thank you, Pavlo. This is a good example. I will briefly comment it. Coming back to this admissibility criteria, when we talk about Ukraine, there were cases when the court stated that if the equivalent is less than 200 euros, these cases will be rejected or dismissed because the applicant didn't suffer substantive damages. With me, it was 30,000 hryvnias, which was still dismissed. These are the criteria of admissibility for the European Court on Human Rights. Pavlo has provided a very good example. So when we are talking about Ukraine, when we are talking about pecuniary damages, the practice is like that. But the applicant can all the time state that for me is quite a substantive amount of money. But if there are no other arguments, the court will definitely reject the case. There was a case, Bazaluk versus Ukraine, where the applicant actually claimed non-pecuniary damages amounting to 400 euros, and he was given 200 euros. Unfortunately, there is no mic. No mic. If the provision of the law is applied in a proper way, so it can be any case, and the sum won't be the key point here. I'm not ready to discuss this case in details because I do not know the case, why the cassation appeal was not actually accepted, was not admitted. admitted. Probably you can send the documents to us. We shall have a look at it, but I doubt that the Supreme Court did not accept the cassation appeal without any grounds. Do you have any comments related to this question, or? Thank you very much for your very interesting approach. I'm a state expert on access to justice, the Ministry of Justice, and it's really nice when you talk about the access to justice, starting with mediation and to the enforcement, execution of the judgments. For Ukraine, usually we get down to the right to free legal aid. And coming back to the issue of access to justice, this is the issue of free legal aid, and we were trying to study the judgments that were related to the guaranteed legal aid. And for several times we stated that such aid should not be just formal, but also effective. And now we try to study all the applications submitted to the European Courts of Human Rights. In your opinion, what is the percentage of cases related to free legal aid or violation of the right to free legal aid? And what is the percentage for Ukraine specifically? And probably there is problem or an issue that we don't know about, but from your own experience you see that it is a significant issue. Thank you. Again, this is my personal opinion. There are practically no such cases. Well, they exist, but as a rule, these are quite general applications. We are talking about certain obligations of the applicant. For example, the applicant should go to special centers, and the applicants do not do it or take insufficient efforts in this respect. So in the applications we get, the situation is approximately like that. Therefore, probably we do not have here any major problems or major issues. Alexei, your question. Unfortunately, our agenda is really very busy today. Therefore, it will be the last question for this report, and later we can discuss this issue during coffee breaks. Alexei Plotnikov, non-government organization, the 10th of April, Odessa. Thank you very much for your report. It was really interesting and informative. And I have a question. Does the case law of the court has any criteria, tests, or rules that the court applies in order to differentiate the right to access to justice under Article 6 and under Article 13? I would like to provide two examples. We just are not very much sure whether we qualify the situation in the correct way. The first situation, a person who is under control of the executive power has a court judgment about her. There is no application that the person probably does not want the case to consider in absentee. Therefore, there is a court judgment against the person, and the judgment is enforced. This is under Article 6. And the second variant is the situation when a person is present in the courtroom. There is the lawyer representing the free legal aid, and the lawyer is doing nothing. So it is just seen from the case that the lawyer just states the rights of the applicant. That's it. This is Article 13.
Thank you very much indeed. I wanted to speak about that, but there was no time, and I am chatty when present. Article 6 is going to be lax specialis with respect to Article 13. Given the following context, there is Shapovalov case versus Ukraine, where the applicant was a journalist and didn't have access to the meetings of the election commission. He was banned from participating. He went to court to appeal that. It it was not provided for by law. And the court considered that under Article 6 rather than 10 in conjunction with Article 13. But if we talk about violation of Article 6, Article 13 can be applied as well, because Article 13 is never resorted to independently. I don't have a convention had, okay, for instance, the right to reasonable period of time or reasonable length of proceedings. We keep talking about violation of Article 6 and Article 13 because 13 says that everybody whose rights and duties are violated is entitled to effective remedies. So if it is the right guaranteed by Article 6 that was violated, so Article 13 can be applied as well. So in case of violation of Article 6, then the question is what are the effective remedies? What the individual can do for the government to remedy the situation. But if that's any other right, Article 8, Article 10, well, these are the main articles, Article 2 and 3. They have their own rules and procedural aspect of the articles. Article 5.5, the right to compensation. But in Shapovalov case, it was Article 10, access to information due to his profession as a journalist. So he can't go to court because the legislation does not provide for a right of a journalist to go to court. So election code was made ages ago. So whether it's Article 6 or Article 13, well, 6 is going to be lax specialis with respect to Article 13. 13 can go in conjunction with Article 6 if you talk about one of the elements of the right to a fair trial. Brief comment. Андрій Мамалига. Very important issue. Access to court as an element of the principle of fair justice and fair trial is very acute for Ukraine, since constant reforms, I would put reforms in inverted commas, lead to the situation when the first instance courts do not function properly. At the end of May, we had 1,500 vacancies. We have the same understanding of the situation, so well, a lot of people justify that by war. If you talk about Stanitsa Luhanska, that's clear, but we are talking about systemic phenomenon here, and it's very important for the judges propose the options for addressing this issue. Roughly 500,000 of Ukrainian citizens that are outside the military action zone don't have access to court. Anyways, they have to go to the neighboring districts where there is one judge who registered the application, but there was no time to hear that. We need to remember that. A very good document that was produced by the Committee of Ministers. It was translated into Ukrainian, called Guidance on Due Practice as to National Remedies. I just Googled it and I found it 64 pages with lots of clarifications as to correlation of different articles of the convention with Article 13, and the latter is usually additional, as Olga said. But with respect to any convention of the article, this correlation is clearly stated in the document. Thank you. Thank you, Olga. Let's move on, and the next session for of the forum is execution of European Court of Human Rights judgments concerning systemic and structural problems. And let me give the floor to Nadia Zadorozhna, legal officer of the Division of the Department for the Execution of Judgments of the European Court of Human Rights, Director General of Human Rights and Rule of Law. Good morning, dear ladies and gentlemen. It's my first time when I participate in the forum. I represent the Department of the Execution of Judgments of the Committee of Ministers of Ukraine, and I'm really happy to have a separate session on execution of the ECHR. Since the subject matter of the conference is the right to a fair trial, Article 6, modern trends, let me focus on this very subject matter. I'll fit into the timing despite the intro remarks that I'm making. The structure of the presentation is going to be the following. The state of execution by Ukraine of the European Court judgments, trends of execution as seen by the Committee of Ministers, execution of the judgments based on the violation of Article 6 with systemic and structural problems, and I will briefly announce the next meeting of the Committee of Ministers that is going to be held in December in a week and a half, and the cases that are going to be heard then. As to the state of execution of European Court judgments, as of today, we have 561 cases, which makes around 10% from the total number of cases that are supervised or whose execution is supervised by the Committee of Ministers. So Ukraine ranks third in terms of the number of cases. The specificity of Ukraine and data on Ukraine is the following. More than 85% against Ukraine are repetitive violations. I'll go back to that when I will talk about systemic and structural problems under Article 6, Merit and Naumenko on excessive length of proceedings. Well, so there is around 100 cases of identical cases. In Zhovnir case, so that's part of Burmich-Ivanov cases, we have 72 cases, absolutely identical ones. And the second specificity of Ukraine is the following. Unfortunately, for a long period of time, there have been no effective mechanism of protection against the specific issues. Looking at the statistics on Ukraine, we see that most of the cases are under the scrutiny. Around 50 of them are the leading cases that show specific violations or elements of violation. Not all cases are dealing with Article 6, as you know, but nevertheless, the share of the cases that show violation of Article 6 is considerable. And before I move over to the discussion of the large group of cases, let me just outline the trends in execution of judgments and interpret the statistics that you can get from HUDOC exec or from the report of the government agent. Let's go to philosophical notion, what is more important, the way or the outcome. And when it comes to the execution of European Court judgments, the outcome, the result is much more important, though you can't get there without following a specific path. Let's look at the results. They are not as optimistic and bright as we want them to see, but Ukraine is moving ahead, and the Committee of Ministers sees some dynamics here. Some of the decisions has the close type of supervision about them, but they deal mainly with the measures of individual nature or non-systemic nature. For instance, lack of a representative in a criminal process. This issue was addressed through free legal aid, and the issue was eliminated. So these are not complex cases. So, in addition to closing the cases of non-systemic, non-structural problems where proper remedies were used by the government, the Committee of Ministers closes the repetitive cases with repetitive violations where the remedies of individual nature were applied and they were proper. Recently, we closed a lot of cases from Ivanov-Burmich-Rovnir group of cases where the government indeed executed national decisions and paid fair satisfaction, but the Committee of Ministers doesn't believe that the case was resolved. But for the sake of case management and for the sake of simplification of work, this strategic decision was made. In 2019, 423 cases were closed. After December meeting, the statistics might change, and in 2018, more than 300 cases were closed. Therefore, these were repetitive cases. As to the agenda, execution of the judgments on systemic and structural problems. Here, let me identify the largest groups. So we have the government agent here. That's the Burmich group of cases and the Ivanov group of cases. That's the largest group of cases dealing with systemic and structural problem of non-execution of the national courts against the state or excessive length of time of execution and lack of proper protection mechanism against this violation. It has an impact on the efficiency of justice, generally speaking. Historically, the Committee of Ministers and European Court have known about this issue since 2001. In 2010, it was pilot judgments in Ivanov case, and in 2017, it was Burmich case judgment. European Court, when delivering the judgment, special judgment by the Grand Chamber, established the deadline for the government. It been 2 years. It expired on October 19, 2019. Last time the Committee of Ministers heard about these cases in September, the previous meeting. The next time that's going to be most likely next March. It was stated in the decision of the Committee of Ministers. So what's the story today? Very briefly, since Mr. Lishina is going to speak about that, and you know a lot about this case. As of the last meeting of the Committee of Ministers where this group of cases was heard, the government presented a national strategy to the Committee of Ministers to resolve the issues in this group of cases. Unfortunately, this strategy has not been approved either as a recommendation or as the binding legal document. We know that the work is ongoing, but we'll see what has been accomplished on January 15. This date was established as the final date for the government to submit information on execution of the judgments in this group of cases. The next group of cases deal with systemic violations that was mentioned yesterday and today. That that's cases dealing with excessive length of proceedings in criminal or civil proceedings. That's group of married or Svetlana Naumenko. Last time the case was heard by the Committee of Ministers a long time ago, back in 2013. Next time it is going to be heard in December, in a month and a half. But I think Paolo Pushkar will speak more about this case. And the third group of cases, and that's a high-profile group of cases that is in the center of attention for the audience. That's independence of judiciary, disciplinary proceedings, and career of judges, group of cases Volkov-Kulakov. Tentatively, the Committee of Ministers had this group of cases in September, and in September they raised two questions that have not been addressed yet, or Committee of Ministers didn't have sufficient information to draw conclusions. That's the issue of appealing the decisions by the judges in cases on the career of judges and their transfer from one court to another. The Committee of Ministers identified another problem that could pose a threat to independence of judiciary. That's application of Article 375 of the Criminal Code, excessive application of this article. Next time it will be in December when these cases are going to be heard, but on different grounds. Not because there is a considerable progress since September until December, but just because there have been considerable changes made that might have a serious influence on the issues in Volkov and Kulakov group of cases. And again, I think execution on that will be covered by Paolo Pushkar. Two other cases, just for your information, they will be heard in a month. Zelenchuk and Zetsura on excessive length of moratorium on the sale of agricultural land that was disproportionate with respect to applications. That was violation of Article 1, Protocol 1 to the Convention. And the second case, Shvedka versus Ukraine, on the following. The applicant over 60, she didn't have a criminal record for expressing her political views. The applicant was charged with hooliganism and administrative arrest for the period of 10 days was imposed on her. The court found it disproportionate because some other factors were not overlooked, and administrative arrest then was extreme sanction for this type of actions. And second aspect, at the moment when the case was pending, the delayed effect of administrative arrest was missing, so the person served administrative arrest, and only after that the person could appeal the decision on imposing the sanction. That could have happened only following her serving the term. Zelenchuk, Zetsura, and Shvedka versus Ukraine will be heard by the Committee of Ministers for the first time ever, and I would encourage you to keep an eye on the website. That's Hudok Execu, with all the judgments and analysis of the judgments that's publicly accessible. And I think it would be interesting to follow the decisions of the Committee of Ministers. Government agent and Ministry of Justice translates the decisions into Ukrainian, and you can find the report of the Committee of Ministers in Ukrainian a week or so after the meeting. Thank you. Thank you very much indeed. Pavlo Pushkar, head of the Division of the Department for the Execution of Judgment of the European Court of Human Rights, Director General Human Rights and Rule of Law Council of Europe. Good morning. Can you hear? I'm really very happy to see you today after the intense weekend day yesterday. I have a short presentation on the things that I'm going to speak about. I'll speak about the methodology of execution of judgments of the European Court, especially given the discussion we had yesterday. The title of my presentation is called Subsidiarity in the context of execution of the European Court judgments in cases on systemic and structural problems. I decided to simplify it and call it a role of the Council of Europe and regional customary law on human rights to provide for the protection of the rights of people in view of the principle of subsidiarity. I'll explain why I decided to simplify it so much in a minute, but let me thank Lviv University and Law Department, that's alma mater in the international law, especially when it comes to individual applications to the European Court. Special thanks go to the OSCE project and Council of Europe project and Council of Europe office in Ukraine for the opportunity to participate in this event to discuss practical issues of convention implementation and European Court judgments.
On behalf of Directorate General on Human Rights and the Rule of Law and the Department on Execution, the judgments, I would like to state that this event is really a high-level event of highest importance in relation to the implementation of the Convention and performance of the Council of Europe regarding execution of the judgments of the Court. But also this event shows commitment of the Ukrainian legal community to the protection of human rights and stresses the importance of consolidated approach to the problematic issues faced by the Ukrainian state and the legal community in relation to the protection of human rights. We should state within this context that taking into account that the case law of the court is inseparable from the convention, it is the source of law and the ground for discussions and disputes with respect to the cases on Ukraine. So once again, it is an important tool of transforming the legal system of Ukraine, as I have stated for several times already. Yesterday, we were talking about the customary law issues, about the state immunities. We discussed the case law on this issue. And yesterday, we touched upon the issues related to the translation of the court's judgments and execution of the judgments. For me, it was really interesting to listen to the report on plea bargaining, and probably in my presentation I will cover all those issues at least partially. So today I will talk not only about the theoretical issues, which later is implemented in practice, but I would focus more how the judgments of the court could remain just not implemented ideal, but how they really can be implemented in practice, how they can become the part, the element of the legal system of Ukraine. And from the report of my colleague from our department, we understand what kind of situation we have in relation to Ukraine. Coming back to the structure of my presentation, it is understandable that the role of the court for the legal system of convention is of highest importance, and the name of the forum is one more confirmation of it. but execution of judgment is impossible when it is just forced. And probably at the end of my presentation, we come to some conclusion why some judgments on Ukraine, particularly when we talk about the cases on systemic and structural problems, so why these judgments are not implemented, are not executed. And I would like to talk about the practical way of implementing the judgments of the court, and will try probably to outline some theoretical model, and will provide some practical recommendations on the basis of practical examples, how the model can really be implemented. And I would like to start with the first issue, the problem of enforcement or coercion in the legal system. So how can we ensure the enforcement in the international law? And the key point is played by the state. This is the statement we should be guided by. International law correlates with the domestic law as two synchronized systems which are interrelated. Probably in the world we do not have any formations, probably apart from the Committee of Ministers of the Council of Europe, in its political and collective dimension, that probably would ensure implementation of the international obligations without any force by means of pactum servanda, by the principle of good faith in relation to the international law from the viewpoint of Article 46 of the Convention. Here we should state that the international law cannot be evaluated as a system of the norms, where the first place will be occupied by the so-called super norms, the norms of international agreements. If this statement were true, then the very provisions of the convention would be executed directly without any additional issues like case law of the European Court or self-execution of such norms on the basis of the national courts. The European case law practice is important. It explains the norms of the conventions and provisions of the convention, taking into account the status of the court and the judges, taking into account the authority of the court, its case law, the authority of the case law. It is really important to explain the provisions of conventions and interpretations of the right under convention. But can the case law of the European Court and the Convention survive independently? Can we discuss them as the only legal tools that protect and implement the human rights? The brief answer to this question will be no, and I will explain why. Coming back to the topic of enforcement in the international law, coercion in the international law, the international law is not a system of rules, and we cannot consider it as the combination of rules. International law is a complicated multi-level system which is mainly based on a process, the process that helps us understand whether we have a certain norm for the international law, whether it is enforced or not. The highest role regarding execution of the international law was is the fact how the state itself enforces certain provisions, whether the state does not object to the enforcement of a certain law. Also, an important role, whether a certain international provision is recognized, is played by the state itself. And this is the example we discussed yesterday. For example, when we recognize the translation as the authentic one, translation of the judgment of the European Court as the authentic one. The judgment of the European Court is the final one, according to Article 46, and the state has to pay a satisfaction, and the Committee of Ministers of the Council of Europe actually recognizes the payment of the fair satisfaction as the part of that should be definitely enforced. So we can talk about a complicated normative system that includes the convention, the case law, the orders of the various system, I mean the domestic norms, rules and recommendations. And the implementation of these norms are done on the basis of the orders of the Council of Europe. And this is a complemented system which consists of interrelated elements, international agreements, the Charter of the Council of Europe, the case laws, the Convention, the domestic case law, the Doctrine of Law of the Council of Europe, the international customs, the norms and recommendations of the Council of Law of Europe, and the so-called soft norms. The system reflects the sources of the international law according to Article 38 of the UN Charter, which are to some extent are reflected in Article 9 of the Constitution of Ukraine. Only the provisions of the international agreements are recognized by the national system of Ukraine. If we use the TV terms, it's like 1D in comparison with 4D, because the Charter of the International UN Court uses such terms as international conventions, recognized principles of law, the opinions of the most qualified specialists of the public law. Therefore, without understanding the specific place of the court judgment, it is impossible to enforce, to execute such a decision. Therefore, no actions of individual character or simple actions of general character, for example, like translation of the judgment, will not be enough to fully enforce or execute the judgments of the court. And here we understand that the court judgment text is very often quite complicated. The law of 2006, which focuses on execution of the court judgments, does not resolve the issue of enforcement and execution. The judgment of the court are not administrative documents. These judgments have really complex character that should be treated as something very fragile and very soft. So how can we fully enforce and execute the judgment? How can we satisfy the requirements of the Council of Europe Committee of Ministers? In order to understand how it can be done, for example, we have to clearly understand the methodology used by the European Court on Human Rights while formulating its legal positions. And also we have to take into account the methodology of the Committee of Ministers of the Council of Europe as a quasi-judicial body that supervises execution of the judgments. And by the way, they do not translate the judgments. The international legal tools that assist to form the case law of the court consists of the actually case law of the courts, because it is all the time develops, it is dynamic, it is evolution, it evolves all the time. And here we also take into account subsidiarity principles. And within this context, I would like to discuss the international regional custom, which was fixed when we talk about approaches of the state to joint or simultaneous development of this issue. Once again, taking into account subsidiarity principle. taking into account about customary law, when we talk about execution of the court judgments, I would like to draw your attention to the fact how we understand subsidiarity. The essence of subsidiarity can be described with one word: belonging or availability. Availability of the catalog of rules at the national level, in the national legal system, when we talk about practical enforcement of the rights. So this is the principle of effective insurance of somebody's rights. So we can talk about two aspects of subsidiarity. We can talk about material and proportional subsidiarity. And coming back to the judgment of the court, I would like to compare these two processes, parallel processes of taking these judgments within the context of systemic and structural and pilot character. And this comparison will be done within the context of distinguishing the roles of these convention bodies. We have to remember the fact that the Committee of Ministers is the statute body of the Council of Europe, and within the system of institutional balance, the Court declares the violation and recommends certain measures how the decisions may be implemented, while the Committee of Ministers supervises or watches the enforcement of the judgment. But they follow the doctrine of subsidiarity, I mean both the procedural, the proportional and material one, and the key role in this respect is performed by the domestic, that means national bodies. So when we talk about formation of the case law or legal position of the European Court on Human Rights, we discuss consideration of individual application. I talk about the decisions on Article 34 of the Convention, particularly when we talk about the norms of the conventions and when we interpret them through the so-called soft law of the Council of Europe. For example, today we have already talked about the guidelines on effective remedies. Another example can be recommendations of the Committee of Ministers of the Council of Europe on judiciary independence, or recommendations of the Parliamentary Assembly. Yesterday we discussed the plea bargain agreements, and here we can mention the recommendations of the Council of Europe of 2009, how we should describe the legislation on plea bargaining. When we talk about soft law or soft provisions, we can talk about expert recommendations of such specialized expert bodies as Venice Commission, Greco, CPC, CPT, and here we talk about their mandates. Therefore, the approach of the court to applying the norms of soft law to recommendations to other sources of international law actually encompasses the whole approach. And by stating this, we can say that the Council of Europe has one voice. The court has never recognized hierarchy of different sources of the international law. Yesterday we heard such cases, Demirci versus Turkey, Chudak versus Lithuania. And while establishing its legal position, the court takes an integrational approach with respect to different sources of the international law. Trying to understand what kind of customary law we have about this or that legal situation, the court refers to the international custom availability of the so-called international consensus, whether there is a certain legal approach to this issue. When we apply the customary law, probably some abstract example can be total, absolute ban or forbiddance of torture. This is an absolute ban, and also this is absolute ban from the viewpoint of customary law. The court can confirm the presence of a certain custom, or, for example, the court may determine the so-called European consensus, under certain circumstances, under certain grounds. And in this case, we can describe such cases ABC versus Ireland. Also, when the court interprets the norms of the convention, the court may use some other sources of international law, and by doing this, the court is establishing its legal position and synchronizes the judgments of the court with the work of the Council of Europe and other norms of the international law. In particular, probably the biggest attention is paid to the norms of the so-called soft law with respect to the protection of human rights. By applying these soft norms, the court refers to the consensus of the state, and probably more classical example of referring to the so-called soft norms is the case Alexander Volkov versus Ukraine, where the court refers to the law on the judiciary and to the recommendations of the Council of Europe on judicial independence. In some cases, the court refers to the norms of the soft law, which do not have formal status. And in this respect, we can remember the case Nemerzhitsky versus Ukraine, where the court referred to some criteria of non-public and non-government organization. It was a medical association which, in the opinion of the court, developed the rules of enforced feeding, and these were the best practices in medical activity.
In Davidov against Ukraine case, the court refers to the politically controversial things that State Department of the U.S. As two special units work in prisons. Muto Dapachstein, that's Article 6, the court referred to FIFA documents and International Chamber of Commerce. It's very interesting when it comes to execution. The execution dealt of private legal provision of the execution of the judgments at the national level. Werner versus Germany, the court referred to the legal framework of Harm Reduction International and European Union documents, the EU Agency on combating drug trafficking. That's rather exception than the rule, despite the fact that this type of references allow for assessment based on their own initiative that deals with structurality and systemic nature, the legal depth of the problem and its comparison with other legal systems, and the court looks into that in more detail. Generally speaking, when the decision is made by the European Court, the opinion then is based on the deduction rather than induction that is applied when executing court judgments. When it comes to execution of judgments, the largest issue given general measures execution, that's the distance of the judgment from the modern time. Another thing that's unclear position of the court as to root causes of the violations. This issue should be addressed at the execution stage based on the principle of subsidiarity, where the government offers solutions as to execution, and the Committee of Ministers assesses that and provides further recommendations based on the legal norms of the Council of Europe. At the moment, the Committee of Ministers in December will talk about efficiency of justice, independence of judiciary, the judgments on these cases, especially in Merit and Naumenko. They deal with the legal events and state of the system in 2004 and 2005. Naumenko filed the application in 1997, 1998. In December, the Committee of Ministers will hear Zelenchuk and Shvedka cases, but how is the government to respond to that, given remoteness in time and unclarity of the position? So what would be the position of the Committee of Ministers now? Let me just point out some of the facts here. that Committee of Ministers of the Council of Europe takes into consideration. On the one hand, a Committee of Ministers assesses the execution of the judgment as to following the recommendations of the court to eliminate structural problems. So the Committee of Ministers at the meeting of a specific case, they establish legal facts or status quo of the legal issue. Committee of Ministers should provide the answer to the question whether the legal situation is different from what it used to be before, and whether the root causes have been addressed. On the other hand, Committee of Ministers takes into account the standards of the law if it matches the recommendations of the Committee of Ministers, Council of Europe institutions, and the overall standards of the Council of Europe. Why? The goal of execution is restitutio ad integrum, but the general measures as well aimed at preventing similar problems in the future. The duty here is the system that does not violate the requirements today and in the future, and prevents repetition of the violations that used to exist before. And it's not an easy thing for Ukraine. Let me quote execution in the Honhadze case. When executing this judgment, both elements, the system of security and safety of journalists and recommendations of the Council of Europe have significantly changed since the moment the judgment was delivered. Ukraine adopted criminal code provisions to strengthen the protection of the journalists, but the government did not take into consideration soft recommendations of the Council of Europe as to how to define journalists. For instance, officially unregistered journalists, people without license, bloggers, do they fall within the scope of Article 2 and 10 of the convention? So in other words, is there a duty to investigate the cause effect in case of homicide of the person that was working as a journalist with its factual activity? That's reflected in the opinion of the Committee of Ministers that take into consideration not only the soft law development but the case law in the country, because the judgment in Hanadze case briefly covers what was the violation of Article 2 and what's the duty of the state to investigate this type of crimes. At the moment, apart from the criminal code amendments, the Council of Europe is cooperating with the National School of Judges to develop the course for the judges on this issue. We appreciate this cooperation. As to the elements pending on the execution that is supervised by the Committee of Ministers, what is taken into consideration when it comes to recommendations to resolve systemic and structural problems? Ivan is here, and we can have a discussion on that. We can discuss this in a wider community. Firstly, the supervision is exercised on the basis of the report of the government or action plan of the government that reflects consolidated position of all branches of power on execution of the judgments. Nazar can share his experience on that. It would be interesting to hear his ideas as well. Secondly, action plan or the report of the government as to measures undertaken is tentatively assessed by the Department for Execution as to the legislative issues, case law, and reports available at the national and international level. Under Rule 9, third parties can submit for the Committee of Ministers information as to their vision of execution and provide recommendations on the issues in question. And in this room, we have people who did that. And I know that some of you submitted this type of recommendations to the Committee of Ministers of the Council of Europe, so it would be interesting to hear your opinion on that too. So, what is considered when assessing the state of execution? Not only this type of information that you see here, but case law development of the court decisions on the lack of violations or existence, finding the applications inadmissible, recognition of the recommendations of the Council of Europe, Venice Commission, CPT, GRECO, etc., expert reports on the cooperation programs that are submitted and done on the request of the government, like the report of 2016, reports of UN or UNHCR, and the most important thing here is the previous practice of the Committee of Ministers. Previous practice of the Committee of Ministers on the court judgment's execution is not only best practice, since that's not binding and is not a legal provision per se. The Committee of Ministers practice that's regional, local, international custom. So these are sustainable norms of behavior of council of countries signatories to convention as to how the judgments should be executed. The practice shows not only how to execute judgments, but when it comes to collective duties with respect to supervision, when the member states watch each other and the committee ministers is taken collectively through the consensus, this practice creates legal certainty and legal expectations of a binding nature. As an example, again, I mentioned fair satisfaction payment based on the judgment of the court. That's unconditional obligation under Committee of Ministers, Article 46, opening of the proceedings, criminal cases in case of torture at the discretion of the state. That's the requirement of the Committee of Ministers, refusal to open the proceedings in case of violating the principle of legal certainty in civil case. That's again the requirement of the Case Law Committee of Ministers. The general principle of supervision is the following. The judgments of the Committee of Ministers can be different from state to state and on the same issues. That's based on collective supervision over the execution principle. So this practice of the Committee of Ministers should be defined either by the law of 2006 or developed in the consistent case law. I mean references to specific requirements of the Committee of Ministers that were adopted in the state of execution of judgments. How to execute the court judgments. That's theoretical, practical model that I can suggest. We can mention a lot of different stages as to how to assess things, what can be done. Some things could be apparent. On the other hand, they are apparent, but we don't always follow them. So here it is very important to underscore them again and again, and repetition wouldn't be unnecessary. You have to look carefully at the content of the judgments, a legal analysis of the facts, application of the convention. For instance, the borderline questions of the applicant, specific provisions of the convention. We need to single out legal position of the European Court. Usually that's one or two sentences from the judgment of the European Court, and if you can't do it in one or two sentences, then there is no legal position here. That's just based on my personal experience. You need to identify how legal position that is applied here should be applied to the effective legal issue. Define the belonging of the judgment to the system or subsystem. Presumption for the case of freedom. Identify the elements of the system as subsystem. Identify the case law of the European Court that the court refers to this and this very judgment, maybe the case law of the Committee of Ministers, etc. Identify the elements of measures of individual nature and general nature necessary for the execution. Apply the measures and report about this to the Committee of Ministers. Full execution is an important thing to report to the Committee of Ministers. Committee of Ministers should be aware when the judgment was executed to complete the supervision stage. I described the obligations that arise given the execution of the court judgments. And to conclude, I would like to say that the duty to provide for human rights under convention, that's the shared duty of all branches of power in the country. Subsidiarity under European Convention of Human Rights within the framework of European Court of Human Rights and the Committee of Ministers of the Council of Europe, when identifying the boundaries of abidance by the convention and how these authorities are going to look into the compliance with the subsidiarity rule. We said that both the court and Committee of Ministers will look at the substantive protection of some rights under the convention from the point of view of both procedural and substantive subsidiarity. We were saying that the court and the Committee of Ministers of the Council of Europe, when looking into compliance with the requirements of the European Court of Human Rights, in particular the Committee of Ministers itself and the European Court in case of repetitive dealing with the application based on the repetitive application to the European Court in case of failure of executing the previous judgment, will look how the process of decision-making at the national authorities was organized, what national authorities took into consideration when undertaking measures to execute European Court judgments or contrary to execution of the European Court judgments. Both assessment processes will be based on the methodology of shaping legal position of the Court and Committee of Ministers of the Council of Europe, so respectively in the course of execution and assessment. Different methodologies, but they are united by the sources of the legal positions, and in the core of that's classical sources of international law that act as norms, and they are based on the process. To execute the European Court judgment, you need to identify where the judgment is in the system of norms. The government executes not the text of the judgment, but norms of multi-level nature in this judgment. And well, it is impossible to execute the judgment otherwise. Thank you for your attention. We'll be happy to answer questions. Thank you, Pavlo, for having found time to come to Ukraine. Thank you for another inspirational speech as to care that we should pursue when executed in the judgments. Okay, so some names we mentioned. If you feel like commenting something, feel free to do that. If not, then questions. Dmitro. Thank you for your presentation. Since you covered theory, so here is a theoretical question. Maybe I'll ask another one later. As to the model of European consensus or European consensus doctrine, what is the basis for us or for you to believe that it is an international custom, and when can we say that this custom has been shaped? An article of the former judge of the European Court, Zimela, she is the head of the Constitutional Court of Latvia, where she describes shapes the way of forming custom, given two elements, European consensus and how to differentiate existence or lack of consensus. So the availability of the trend and lack of customs. ABC against Ireland. That's where it is disclosed. I can share all this with you. It seems to me that it's very important to understand here what is the level of the Committee of Ministers with respect to fixing international and regional custom. Custom is shaped through national case law when applying the international law norms, and it is recorded in the decisions of the Committee of Ministers. So international law and international custom are shaped by the national authorities. There is a difference here as to who plays the key role in shaping the custom, whether these are lawmaking authorities or executive authorities or judiciary, but the state shapes the custom, generally speaking. And there are two segments here. That's sustainable legal practice, case law that shapes sustainable trend in the behavior of the state with respect to international law norms. And on the other hand, that's custom in the relations between the state as it is shaped at the interstate level. So a system of international law norms seen as the system of legal norms only is impossible to do, because that's a complex system of norms and the correlation of norms were disclosed in the works of Butkevich and Lukashuk, and I don't think we need to repeat all that now, but deficiencies of Article 9 of the Constitution, where international custom and generally recognized international law norms are not part of Article 9 of the Constitution of Ukraine, that's a serious problem. So the custom can be found in application of different legal acts and laws, but Article 9 itself creates the flat dimension of international law as it is seen by Ukraine. And given all this, we can say that we have the problem in perceiving these norms of the Council of Europe standards and the court judgments execution. On the execution, here is one question. Can you name examples of the European consensus as to execution of the European Court judgments dealing with the violation of the right to defense in criminal process? We can talk about stable case law as well, but, well, you said that it is shaped through national courts. Saldus versus Turkey, for instance. To some extent, it was revised through Grand Chamber judgment. That's access to the defense lawyer. What is meant here that as part of the execution of this judgment, that was the judgment delivered against Turkey, and erga omnes with respect to indefinite number of people that we mentioned yesterday. The Netherlands, given all that, changed their legislation based on the requirement to execute the judgment of the European Court against Turkey. My question was about different things. My question was about the situation when the Committee of Ministers of the Council of Europe takes into consideration European consensus to establish whether the judgment was executed or not. For instance, a country executed the European Court judgment differently from other 46, better or worse? Well, let it be better. So can we be guided by European consensus here and say that the execution should be done differently? Well, differently from the others. Is there any analysis on European consensus, in particular when it comes to execution of judgments? Not a lot. Thank you, Dmitro. Very complex and an interesting question. Maybe you have an opportunity to speak about this more in your scientific work. Indeed, I quoted the example of fair satisfaction payment. Fair satisfaction payment under the European Court judgment is an unconditional obligation. And that's the practice of the Committee of Ministers of the Council of Europe. It's not a direct requirement of the judgment, though in its operative part, a judgment makes you do it, but any objections as to impossibility of paying fair satisfaction are not accepted by the Committee of Ministers because that's unconditional thing based on the Committee of Ministers case law. In other cases, absolute ban of torture and a requirement to reopen the proceedings. That's the case law of the Committee of Ministers. There is a European consensus due to the absolute ban of torture. It's not expressed in the forms of European consensus and it doesn't deal with the national court practice. That's rather the case law of the states. European consensus is a new autonomous criterion of interpreting the convention requirements that didn't work partly in the European court case law, though a lot was written about it. For instance, similar to the concept of living together as an autonomous term in the European court case law, it didn't work as the criterion to assess margins of appreciation of the state on the cases with respect to freedom of expression.
Here, actually, we talk about the sustainable practice of the states with respect to execution and the expectations that appear on the basis of the sustainable practice of the Committee of Ministers. Valentina has the question. I would like probably to come back to the first recommendation of yours, how we can just determine or identify the content of the judgment, the essence of the judgment. Actually, my question is, do you somehow communicate with the very court in order to understand the essence of the judgment for yourself? Then we have to understand its content. I mean, we as the courts and the government. And it seems to me at this particular stage, we are a bit hindered. Well, we are willing to execute the judgment, but we do not clearly understand what we have to do for the Cabinet of Ministers to recognize our actions as the correct ones. So can we talk about certain, let's say, bridges, how we can expedite understanding the content of the judgment? Thank you very much for your question. Here we have the working feedback, but actually we are the linking element between the Committee of Ministers of the Council of Europe and the European Court on Human Rights. It is our department that has this double mandate. On the one hand, we are legal advisors to the Committee of Ministers of the Council of Europe. On the other hand, at request of the state, of the government bodies, if they wish, we can provide certain recommendations what should be done to execute the judgment, what is expected by the Committee of Ministers with respect to a specific judgment. And today I was trying to present the methodology we use. I really wanted to share this methodology. For us, it's very important to understand the content, the essence of the judgment, because when the court is building its judgment, it actually makes up the puzzle. What we are doing is disassembling it. We try to understand the causes for the violation, why certain element doesn't work, why we have certain repetitive violations. And in our cooperation with the government, And if we talk about the national strategy that was developed on the support of the Council of Europe, so we really evaluated very attentively what is possible and what is not possible, why the judgments are not executed. Actually, we have exhausted, it seems to me, all the means we have. We studied the smallest details. The root causes are understandable, and due to the consultations with the European Court on the basis of the Committee of Ministries practice, we have to develop this approach. If we talk about the judgment Volkov versus Ukraine, the situation is clearly understandable. We understand how we should evaluate the amendments to the legislation. This comes from the very judgment. In the judgment, we have the guarantees of judicial independence that are based on the principle of distribution of powers, on the principle of replacement, impossibility to replace judgment, and on certain principles of judicial performance. So all these issues were taken into account when we evaluated the situation. If we take about this case, Volkov versus Ukraine, and the amendments to the legislation. So when we talk about the merits of the case, we try to study the problem of excessive length, excessive period of consideration, and excessive period for execution of the judgments, which are really sometimes excessive and long in comparison with some other countries. For example, if we take Italian cases, on the one hand, we have the situation when for a long period of time, the judgments of the European Court on Human Rights with relation to excessive length of consideration, Italy suggested certain means to remedy the situation, and still they were not effective. So we should analyze the situation and think what else can be done here to improve the situation. So the role of the national coordinator within this system is to consolidate and to present the joint position, the joint stance of all the branches of power, how the judgments of the European Court can be executed. And the role of the national dialogue in this particular forum is of crucial importance, because we have to discuss the problems in order to later address them. Thank you very much for your report, talking about execution of the judgments of the European Court. Every judgment implicitly means that the situation should not be repeated. Definitely it is not stated, but it is understood. It is meant that the state should prevent the repetition of the negative situation. What is your opinion? When we have some other applications on the same violation, can we refer to the previous judgment and the fact that it was not executed? For example, if the state, for example, states that there is certain violation, the state provides a report on execution of a certain judgment, and in this report the state, for example, says that there were trainings for the state employees in order to prevent such violations, so some other measures were taken. The court says that the judgment is executed. Okay, that's finished. We did not discuss how the trainings of state and civil servants were organized, etc. But actually, we see that similar violations will not be monitored in future. It looks like the problem is just hidden somewhere, is put, let's say, under the table. So there was the violation, there was the complaint to the European Court, there was the judgment, then there was a response of the state, and later probably the state bodies will try to cover up the violations which will appear later. Here there are two aspects. Probably in this case it will be more interesting for you as the non-state organization to go to the procedure of the Rule 9 of the Committee of the Ministers. And we have the information at the website, and Nadia or I can share this information. Here, we talk about the point that apart from the state that provides reports on execution of the judgment, also, non-government organization can refer to the Committee of Ministries, and they can recommend certain measures of general character that will ensure that certain violation will not be repeated. Also, it can be done by the government, by the Ombudsman on Human Rights, and Irina is present here, and I think she knows the procedure. We had one application, one request of the Ombudsman within the context of Burmach case versus Ukraine, and certain interesting aspects were revealed. The government has its own stance, but this stance probably will not always coincide and be consolidated with the human rights protecting organizations and the institutes of human rights. There are such countries as, for example, Armenia, where the Ministry of Justice has meetings with the Ombudsman and discuss how they can implement, how they execute the judgments of the court. This because there could be certain variants, certain elements which are not noticed by the state. For example, if we talk about the trainings of judges, here you have to cooperate with the judiciary, with the National School of Judges. Talking about the civil servants, also a similar issue. I understand what is the essence of your question. I think that these issues are still in the focus of the Council of Europe, but probably some other monitoring bodies are active in this case. If we take penitentiary system or law enforcement bodies, there are some other tools available in the Council of Europe to monitor the state of things. But really there is a difference between the single violations of conventions and repetitive violations, which cause certain systemic and structural consequences. In our understanding, when we are informed by the state that, for example, the state organized trainings for some civil servants, we understand that the trainings were not just of formal character. We understand that the information was presented and people later implement the result and the information into life. And in order to check, we can see the case law on this issue. And later we can request the information how the trainings or some other measures influenced the state of things. So we really studied the statistics, for example, whether the number of detainees has increased or vice versa has been reduced. We have a number of important indicators and tools. For example, we take a number of requests on the part of the state, we take the information from the public space, we try to evaluate the information, and we come to a conclusion whether we really prevented the repetition of violation, or vice versa, whether the violation might be repeated. I have a very brief question on Burmich case. Burmich actually united a number of problems related to non-execution of the judgments of the court. Now the government, the state identified the problem, why it's like that. Now the question. Well, the state will try to remedy the situation, will correct the situation. But nobody guarantees that some new issues, problematic issues appear that will aggravate the situation. And while the government will be working on identified problems, some new ones might appear. And my question is the following. Can the Committee of Ministries add some more issues later? Can we talk about autonomous communication with the government, let's say behind the back of the European Court? So actually, we can talk about the beginning of the execution process and the final point. For sure, there should be some final point, and the government, the state, has to prove that this is the final point. The problems were addressed, they were resolved at the national level, and there are no new obstacles to the execution of the judgments. I was talking about Volkov and Kurikov's cases, so we shall try to study whether the problems won't be repeated. I mean, the problems in Volkov's case, and when we talk about Burmich case, it seems to me this is through the national strategy that we try to reiterate to the government of Ukraine that the national strategy is your roadmap, and if you follow this roadmap and if you explain to us that it has been implemented within the time frames and within the deliverables mentioned to us on the basis of subsidiarity principles, then the Committee of Ministries can really put a dot here. However, so unfortunately, right now we cannot talk about significant progress because at one of our sessions in September, the state actually provided to us the report that the national strategy has not yet been adopted either as a recommendation document or as the action plan. And the amendments to legislation were discussed. I mean, the systemic changes required by the Committee of Ministries. I mean, they are of multi-aspectual character. They are about institutional independence of the enforcers, about the automatic execution of the judgments, enforcement, the financial system, the bankruptcy issues. So really, there are a number of aspects that should be systemically addressed. So unfortunately, we do not have here Mr. Kostin, who is the vice head of the subcommittee of the new parliament. Recently, he informed us that on the 25th of March 2020, the Parliament of Ukraine will have hearings on execution of the European Court of Human Rights judgments. And probably Burmich case will be the key segment here. For us, Burmich means 80% of all the work. Though we cannot consider this case to be exceptional or the most significant, because there are some other elements as well. There are, for example, cases related to tortures, presumption in favor of freedom. Some other issues are of top priority, and really we have to take into account all these issues and with due attention to each of them in order to prevent repetitive violations. Thank you. Talking about the strategy, it really has been developed together with the representatives of the Council of Europe and the government agent. And the strategy includes a number of tools to prevent the problems. The fact that the new problems appear cannot be denied. Really, we knew certain issues with IDPs and some other elements. So really there are a number of mechanisms like interagency commission that will include representatives from 3 branches of power, and the commission will be responsible for ongoing monitoring of new cases and related to non-execution of the judgment. There is also the parliamentary control. There is also a mechanism at the level of presidential veto. I mean, the veto of populist laws that may result in non-execution of European Court judgments. I have to admit that taking into account the budget approval and the government program, so far we have not adopted this particular strategy, but Burmich case actually is one of the indicators for the performance of the Ministry of Justice for the next year. So in any case, we pay attention to this. Talking about the dialogue between the Committee of Ministers and the government, let's say, beyond the activities of the European Court on Human Rights, there may be changes in the legislation, and I think that when we discuss the Volkov case, together with the Cabinet of Ministers, we are going to continue the dialogue. Thank you for your attention. I do not want actually to take time from Mr. Sidorovich, who is an expert on Burmich case. Anyway, Burmich case is mentioned also by Ivan, so that was really nice to hear. It probably one remark, the final remark from me. We can just studied the execution of judgments in the Russian Federation, the cases on Yegova witnesses, when there were certain positive steps, and how the Committee of Ministers evaluates the amendments to the legislation related to the recognition of this organization as such that actually should be penalized in a criminal way. So the discussions were about the fact that these were new facts which are considered in the court. And here, for example, you may take such case as Mr. Mamadov versus Azerbaijan and the judgment in this case. It was the article on violation of Article 46 of the Convention and the judgment of the Grand Chamber. And the court actually distinguishes the powers. For example, the powers of the European case and the repetitive case, so the powers of the European Court and the powers of the Cabinet of Ministers of Ukraine. And there is very interesting point in dissenting opinions, because the judges really split, and the decision was taken that the article was violated on the grounds that the judges considered that the remedies of individual character were not applied and the person was not released on the basis of charges. The charges were recognized as arbitrary by the European Court of Human Rights, though the person already was imprisoned. The person already was detained under Article 6, while the violation was found under Article 5. So that was an interesting point about the dialogue between the Cabinet of Ministers, the Committee of Ministers, and the European Court. Thank you very much for your report and for a great discussion after this. Now I announce coffee break, but it will be short, 10 minutes maximum, and after this we give the floor to Ivan Lishina.
We continue our forum. Let me give the floor to Ivana Lishina, Deputy Minister of Justice, Government Agent before the European Court of Human Rights, who is going to speak about representation of the state interest before the European Court via execution of high-profile cases of the last few years. I'm Alishina. I'm government agent before the European Court of Human Rights. I am the main opponents of the human rights activists and attorneys in the European Court. I want to tell you how representatives of the state see this or the other judgment. Nazar could be a good presenter on this too, from both sides. Well, actually, me too. For your understanding, the government agent has sometimes two opposing or two functions that are hard to link together when it comes to representation. The government agent introduces and represents the state in the European Court, submits the position of the state and opinion, and if the decision is made in favor of the applicant, the government agent is in charge of coordination of the execution of the judgment. Sometimes, being aware of the complexity of execution, we choose respective strategy of representation. Sometimes you represented the state, but it could be an obstacle in your further career, as it happened with Ms. Lutkovska, that presented their position as to independence of the governor of CISU, and then as ombudsman, she appealed the investigators as not independent authority. The process of representation in the European Court of the interest of the state starts with the so-called communication that the government agent receives. So that's the information as to judgment, and then he starts collecting the evidence. I would like to focus on two cases, cases, that's good, but I would be able to fit that into the time frame. So I'll speak about politically colored cases, or let me rephrase, cases that require general measures more than anything else. Zelenchuk and Tsutsura and Polak. Polak didn't come into effect yet, that's why I'll be cautious there. Zelenchuk and Tsutsura case. When the case was communicated to the government agent, it turned out that the government doesn't have a uniform position as to the moratorium on land, and reasons for that. When we started collecting information, so either the information was not provided or it was a limited scope of information that we received. So we had several meetings with representatives of different authorities trying to fish out some ideas from them and figure out the reasons for the moratorium. In the course of searching for the information, we started doing our research. For instance, land moratorium. Where did it come from? Why did the government decide that on the one hand we needed to vest the farmers with the right to property, on the other hand limit their ability to alienate the plots of land? So we went back to the parliamentary debates when the land code was adopted and figured out that the government was against limiting the right of farmers to sell land. And the situation was the following. A large faction of communists then believed that right of land ownership shouldn't exist. If it does exist, then alienation right should be limited with a 30-year period. The head of the parliament, Mr. Plush, then said, okay, let's not make 30 years, but make it 6. And that the root cause for this enigmatic 6 years that were difficult to explain to the European Court. That's what Ms. Yutkivska mentioned yesterday. Zelenchuk and Tsutsura judgment is based on insufficient information as to moratorium and restricting the right to sell land. To show the political context, we collected the information of different sources. That's Ms. Tymoshenko and farmers speaking on the rallies before another attempt of the government or parliament to adopt the law on the land market. From the very beginning, we realized that it is next to impossible to win this case. What shall we do then? If you know that the story is complex and the case is hard to win, we believe that it was necessary to show to the European Court all potential grounds and circumstances for our legislation to be approved, so that the court will understand or take into consideration economic and political context here. On the one hand, we are talking about individual rights of the applicants. On the other hand, there is social consensus in the country. If we have a referendum about revoking the right to ownership of land, the decision would be no. If we will ask if we want to open the land market, so most likely the answer will be no. But the context should be taken into consideration by the court, and it did, but naturally the judgment was not in favor of the state given the stance of the applicants. And we should thank the European Court for the choice of applicants. These are two pensioners that lived in the towns 30 and 50 kilometers away from the plots of land that they owned after the division of these pieces of land. They couldn't cultivate them on their own, and they couldn't lease it. Well, this right was limited too. European Court in this judgment noted that unfortunately Constitutional Court twice, when considering this question, overlooked this issue. European Court assessed the influence of the constitutional norms on the land ownership, tax legislation, statistics on land, and legislative proposals and civil society sentiments as to land market. The Constitutional Court had twice to consider that, and the Constitutional Court didn't look at the historic info here and looked at the recent moratorium and decided that extending moratorium for another year, that's actually formality. Moratorium is internal until the law on land market is going to be adopted. Nevertheless, that's within the discretionary powers of political authorities. European Court applied the following principles in this case. The overall maxima saying that a guarantee of rights should be effective, pointed out to uncertainty of legislation and case law that arises from the way the authorities apply it, abidance by Protocol 1 as to procedural and other guarantees that should be in place, and individual difficulties of specific persons as well. European Court carefully studied the history of a moratorium from the very first days of moratorium being introduced, and it was the goal then not to allow selling plots of land. Later, moratorium was extended due to the process of division of pieces of land. Another ground was the Registry of land, and when the European Court said that the process was completed until 2009, so further extension of moratorium was explained by political considerations, such as possibility of foreigners to buy land, impoverishment of farmers, and other political or imaginary grounds rather than real practical reasons for that. The European Court noted that there is another thing. I am not sure whether European consensus can be applied here, but European Court pointed out that in none of the Council of Europe member states there are restrictions like they exist in Ukraine, and that gives general understanding of the circumstances. European Court said that indeed, there are different restrictions in place in different countries. For instance, in France, the state can review any sales agreement. It's not only about arable land, that's about any property. And if they believe that the price was lower, then they can undertake the rights of a buyer. So by paying money to the owner. And there was a case in the European Court on that. That's an old case. But the mechanism exists today as well. It's very logical and clear for all parties. There are bans with respect to large concentration of land in Austria. There are measures to increase concentration in other countries. So in other words, every country finds its own way to develop principles and accomplish the goals through different restrictions imposed on agricultural land disposal, but none of the countries has any general ban as to selling land. And European Court, again, that's efficiency of the Parliament, that it would be logical to first have strict rules that would be mitigated or become softer later. In Ukraine, we have the other process around. So when a legislator saw that there is a chance to circumvent the moratorium, new laws were adopted that restricted the right to sell land even more. European Court pointed out that the goals stated by the government were selected not because it was official ground for the adoption of respective legal framework, namely concerns that foreigners can start buying out land and impoverishment of farmers or rural citizens had nothing to do with the applicants. So limiting ownership of foreigners can be achieved through other ways, as it is proposed in the draft law that is currently in the parliament. So to open the land market, but to ban ownership of foreigners if it is agricultural land. So there is no need to introduce or impose the general ban. So the applicants, we are not people that lived in rural area, so they were urban citizens. So this measure had the impact that was absolutely contrary to what was meant to be achieved by the government. So in fact, they were poor. On the other hand, representation of the state is very important in the European Court. We assist the court to consider the case fully in all its aspects. And some of the arguments we had were taken into consideration, in particular the fact that applicants and those who they inherited the land from received it free of charge. So European Court noted that this land was divided between the farmers, so they cultivated this land, and you can't therefore say that it was ungrounded distribution of land to them in particular, so they were lucky. So no, that was part of the due process, but they haven't paid a single cent for this land. And because of that, the European Court came to the conclusion that given that circumstances, the court wouldn't establish fair satisfaction to be awarded in the form of monies, and the judgment of the European Court is the fair satisfaction in this situation. It's not the first judgment like this made by the court, but one of the landmarking ones. In fact, this judgment is quasi-pilot judgment. So European Court, in fact, applied a unique approach that allow for turning this judgment for the pilot judgment. The court said that they are not going to establish the period of time for pecuniary compensation to be awarded for the violations, but if the government doesn't apply the general measures to prevent and terminate this type of violations, the court will start awarding the compensations. For the government, for the state, it has similar effects with the pilot judgment. When the government faces the specific period of time, though it is not directly defined, but anyways, we realize that it's there, and within this period of time, we need to undertake measures of a general nature to overcome and address a systemic problem. From my perspective, when this judgment was publicized, the government had really diverse response to it. If you compare that with Burma judgment, we set up the intergovernmental group to execute that, and when it comes to this judgment, Ministry of Agriculture didn't show up there at all. They say that this judgment has nothing to do with them. Instead, they sent the representatives of state land registry, who said, well, everything is fine with us. What's your problem? The land can be sold. We asked them, okay, is it any land? Well, not any, but you can. An interesting element here is that they were supported by representatives of the land law of the Ministry of Justice, which was an unexpected move for me. But then it was clear that the draft law that was developed jointly with the IMF or the World Bank, I can't remember now, was in fact swarmed in the discussions of associations of farmers, and it didn't reach the parliament. These fast steps undertaken by the new government will allow us for at least mitigate the tension with respect to the European Court judgment. I'm not going to say in advance that if we adopt the law and it comes into effect, then we will fully resolve the issue or issues raised in the Zelenchuk and Tsetsura case, but will be a lot closer to the execution, and the situation will be much better then. When we submit the submission on these cases, it's very important to present all possible aspects of why the government came to this or the other solution, even if it is not directly linked to the government. For instance, farmers' participation in rallies with their slogans. So the court should understand the context for the decision to be made. Polach versus Ukraine is the judgment that has a similar context. It was necessary to show to the European Court what was the political context for the illustration legislation. European Court
when the first cases were communicated, I actually had a number of delegations of prosecutors who underwent lustration with a request to be brought into power. And it is logical that it was quite difficult to understand whether we should conclude any agreements with them, or if yes, what should be the grounds for this. So, on the other hand, when we started preparing, unlike the situation with the land plots, lots of people were willing to help us, but this assistance was of more political character. For example, if we do not do lustration, tomorrow the Russians will come and there will be very negative consequences. Or, for example, there were statements like that: without lustration, we are not going to have any opportunity to work further, and it's necessary. And the classical lustration was organized within the context of post-Soviet condition, and certain organizations were found as illegal ones and were dismissed, like the communist parties and the secret intelligence services, and their employees were illustrated. And we actually do not do such things. The border guard service and the law enforcement bodies stay as they were, and therefore we apply the de-individualized approach. And moreover, we have some issues regarding the grounds to lustrate. All the judgments adopted by the European Court on Human Rights with regards to lustrations were related to post-Soviet situation, when the European Court and the Parliament recognized that in order to protect young democracies, it was necessary to lustrate those persons who potentially could interfere. And what about the situation when the certain bodies before 2014 and after 2014 remained the same, and lots of employees who were working before 2014 continued working after 2014. In this respect, we were really assisted by the opinion of the Venice Commission, which, in its opinion, admitted that there were grounds for lustration, and the European Court on Human Rights was somehow very much cautious about it and stated that generally there were grounds for lustration. And for us, it was really a victory. It means we proved that under the situation of 2013-2014, the influence of Yanukovych's regime onto the civil service, uh, usurpation of power, and after it very tough and severe actions with respect to Euromaidan, really were grounds for lustration. Though the European Court stated very cautiously, they stated there were grounds for significant reformations, so not for lustration but for reformation. But again, there were grounds, that was the statement. But if we apply the grounds to specific applicants, there were 4 of them. Here there are some issues whether these particular people were lustrated in accordance with the stated goals of the Lustration Act. And here the European Court drew attention to the following points. Why this judgment is interesting? Because actually it explains how it could be done in a correct way. In certain paragraphs, the European Court explains what were the grounds or could be the conditions when it would accept the individualized lustration. For example, the European Court states that if lustration were applied to the top positions, for example, let's say the president, the prime minister, the head of the security service of Ukraine, this is my statement, not the European Court, then in that case, we can beforehand state that you should not prove that this particular person, let's say the head of the security service of Ukraine, was knowledgeable about the certain actions related to the homicides in Maidan. Probably the European Court would accept it as de-individualized lustration. The second variant, if the consequences of such de-individualized lustration were insignificant. For example, if the person was transferred to a less important or less significant position. But the way it was done in Ukraine, when the level of employees who were covered by lustration was really wide, these 4 applicants I'm talking about, one of them was the director of the Department of the General Prosecutors, vice head of the District Prosecutor, vice head of the Regional Tax Administration, and head of the District Tax Administration. So these were people of, let's say, medium level, not very high level, and there was no individual liability established about them for their actions, but the consequences were really serious. They were dismissed from their positions. They were banned to occupy the positions in civil service for 10 years, and the information about them was published at the website, lustration website. So the European Court found violations. What is good about it? What is bad about it? What is good about it? The European Court on Human Rights definitely, its judgment doesn't mean that we have to cancel the act and pay the compensation, huge sums of compensation. But probably it means that we have to amend the law. We have to establish specific cases when lustration can be de-individualized, and in other respects it should be really related to individual liability. And finally, probably, I do not want to state 100% sureness, but probably we have to establish certain amount of compensation for unjustified or ungrounded lustration. Once again, the European Court had all the aspects. For example, the very fact that lustration started as garbage bin lustration, and after the law was adopted, it was somehow neglected. It was also another plus. And the fact that the European Court accepted the situation, the usurpation of power by Yanukovych and attack on Maidan, And what the European Court didn't accept is the consequences of the situation, the attack of the Russian Federation. And these consequences were not definitely accepted with respect to these civil servants. And I really would like to know whether this point will be addressed when we shall, for example, discuss the actions of the border guard service people that somehow contributed to those military actions. That's everything from me. Thank you, Ivan. Are there any comments? Are there any questions? Yes, Dmitry, you have the floor. I have a number of issues with respect to your report. For example, you stated that the European Court recognized that there were grounds for lustration. If we do not discuss this particular judgment of the Court, if we read the resolution of the Parliamentary Assembly of 1996 about completing the disassembling of the Soviet heritage, let's say. So if we read the resolution, can we think that it encompasses Ukraine? It covers Ukraine after the Revolution of Dignity? A very good question. No mic? There is no mic, unfortunately. Looks like mic doesn't work. So we really had to wait for the judgment of the European Court. The question was whether we'll be able to convince the European Court that we had similar conditions in 2014 with those circumstances that were in about 90s, in the year 1990s, in post-Soviet countries. What was in our favor? There was quite active highlight and coverage of Euromaidan events in Western mass media. What was against us, that according to the result of lustration, the system of state governance has not changed. What actually happened after this violent revolution in post-Soviet countries? For us, it was important to see what the European Court would rule. Anyway, if we read that resolution, probably we could just plan lustration in a different way, but as they say, we have what we have. But so far, I have not grasped your opinion completely. While reading this resolution of 1996, did you understand that the principles set there can be applied to any lustration and not only to the lustration with respect to the totalitarian regimes of the past? In my opinion, it was obvious from the very beginning that the same criteria can be applied to all types of lustrations. But the question was slightly different, whether the European Court on Human Rights will recognize the grounds for lustration in general. In my opinion, it was obvious. And actually, to prove the grounds for lustration at that time was much more difficult than, for example, undercarriage conditions. It seems to me here is the problem that lustration had specific context for a big part of Europe, while the Revolution of Dignity probably a specific case or probably a peculiarity of just one country. And probably when we take the criteria of 1996, so probably there will not be direct relation of those criteria to our country. In 1996, nobody can predict that something like that would happen to Ukraine, particularly with respect to just getting rid of the remains of the totalitarian regime or system. In my opinion, lustration should have certain general criteria and general approaches. And coming back to the situation, the European Court directly stated that it takes into account the Ukrainian context and the political context, though they quite formally stated that when Ukraine just was talking about the results of 2015, Ukraine didn't refer to the law on lustration, but the European Court on Human Rights stated that they would take into account the general context, the general situation. Irina, you have the floor. In your presentation, you were talking about Article 216 of the Criminal Code of Ukraine. As I was one of the authors, I can state that everything was fine with the reputation of the Ministry of Justice and the Ombudsman. The agent really submitted it and ran it, and the Ministry of Justice stressed, as always, that there was no problem. But my question is slightly different. It's about some aspects of your report. Execution of judgment is legislation, education, administrative bodies, the judiciary, and actually coordination is with the hands of the Ministry of Justice and probably in your hands as the agent in the European Court. So your own experience, you have some practice, and probably it shows that Ukraine needs a specific structure on execution and coordinating the judgments of the European Court. And if you agree with me, then what kind of form this structure should take? Thank you for the question. This is my old idea, which unfortunately I didn't manage to promote during the previous government, and I hope that probably this convocation, with this government, I will be more successful. Talking about coordination of some general activities, because with individual things, it is slightly different. For example, when we talk about effective investigation, how can you make the prosecutor's office do effective investigation is just another issue. But coordination of efforts of three branches of power at the level of the Deputy Minister of Justice, I would say, is not really something we see right now. What is very valuable for us is the Polish experience. Once where in 2000 they had the same number of cases, but in the year 2000 and that period, they already on the level of the European countries, Western European countries, they really established the interagency working group. We may think what kind of coordination will be there, and still the group ensures the coordination and the dialogue between different branches of power. And this group sets the task to each body, then each body reports and accounts, and then the general action plan is developed for the whole state. In my opinion, this is the best way, the best model to follow, and I do hope we'll be able to implement it as part of the our action plan with respect to Burmich case. It's not directly about Burmich case, but it can be one of the ways at least to establish the same system or similar to it. Yesterday, I just mentioned the expertise of the Council of Europe 2016-2017 with respect to the law of 2006. And this is probably the key issue, which is the matter of this expertise. And I will probably divide it like that, taking into account what Ivan has said and what Irina has mentioned, whether the state bodies, within the frameworks of their powers, how they follow or execute the European Court judgments, or we should establish the parallel structure to the existing state bodies responsible for execution of the court's judgment. It seems to me the answer is obvious. Execution of the court's decision is one of the key tasks of the state bodies, and establishment of some additional or parallel structures will not always be helpful. And for example, we can take here the activities of the interagency working groups, which serve as advisory bodies to the Cabinet of Ministers of Ukraine. For example, if we take Brumach case, the interagency working group unfortunately was not even able to adopt the national strategy on executing this judgment as recommendation. So this is the body that should recommend the state bodies certain actions. But the key actions discussed in the expert is why don't we work directly? Why don't we work through the Cabinet of Ministers that actually has contacts with the other branches of power that is coordinating these activities? We have here Nazar, we have here Irina, who participated in the office work of the government agents in 2006. Probably they will be able to comment it, because the idea of the law of 2006, which was planned, was that the government agent is the agent of the government who is supported by the Secretariat of the Ministry of Justice. And what Ivan states now, that we should bring it to the level of the government, that the government probably should take specific decisions on execution, should come into contact with the judicial power, etc. And expertise includes the list of 20 recommendations. This expertise is available at the website of the Council of Europe and the website of the Office of the Council of Europe. There are working translations into Ukrainian. So to some extent, it's a roadmap. We discussed it just 1 week ago when we discussed our cooperation with the Parliament. And here we have Ruslan, who will probably support me that it really was the case about cooperation between the Council of Europe, Parliamentary Assembly, and the Committee of the Parliament and Subcommittee on the Legal Policy. Unfortunately, Mr. Kostin is not with us today, but let's say he's mentally with us, and we all the time think about him at similar platforms. So we really discussed these issues in details, and I would call it a roadmap. I'm sorry, I have a flight, and I have already missed one this year, and probably cannot afford missing this one, so I have some very little time. Probably I have not a question but a comment. I am a civil servant with great experience, and we all the time joke that if you don't know what to do, just establish an interagency working group. So probably I will not support the statement that the government agent lacks powers. I probably support what Pavlo has stated, that the task of the government agent is to formulate the content. Therefore, this person represents the government, because later the issues should be given to the level of the government, to the level of the parliament. And if we think that we all do our best, then the task is, here is the problem, here is the task, here are the measures to be taken, and everybody should fulfill these measures at his or her level. Unfortunately, we still have the situation when a number of the decisions that should be made are pushed in case it is impossible. The government agent goes to the Cabinet of Ministers, to the Prime Minister. But it seems to me we cannot create a special body that will try to reprimand all the other bodies that cannot or do not want to perform their activities. The state mechanism is functioning the way it should function, and it seems to me it's enough to have this state mechanism. The key problem, in my opinion, is different. Ukraine spends too much time on imitating execution of the judgments of the European Court. And it was the case with all the previous governments, and unfortunately it's still the case right now. So if we talk about imitation of activity, we can list a number of reasons why it's like that and why we cannot act differently. Thank you.
Dear Ivan, you paid attention to the high profile, as you called them, cases on moratorium, on lustration, clarification Pitukhov versus Ukraine criminal jurisdiction. That's the right to hope for people sentenced for life. In one of the paragraphs, the European Court judgment says that the problem of general nature is there because there is no court supervision over the enforcement of the right of a convict to be released. How does it relate to practice? The thing is that the Grand Chamber of the Supreme Court once in 2 weeks roughly handles the complaints of lifers against the commission set up by the president. That's the Commission on Pardoning. And the court makes judgments on this category of cases. Is there any contradiction here? European Court recognized that the Commission is not effective remedy given the right to hope, protection, or enforcement. So appeals to the Commission are not sufficient, therefore. As to Pitukhov, I hope that will be able to vote for the draft law. The text is ready. Pitukhov it's actually a technical issue. There are judgments tested in other countries, post-Soviet countries, where the similar situation existed. We sort of, copy it from Lithuania and introduce specific changes. We suggest that in 20 years he has the right to go to court for second release, and there are 3 options for the court. The person stays in prison for 5 or 10 years, or the motion is dismissed. And in 5 years, he'll have this chance again. That's the system that was introduced in Lithuania, it seems to be, or in Latvia. Lithuania. And while Cambria closed the proceedings because the execution was recognized. Hopefully we'll manage to do that too. Thank you, Ivan. We're supposed to have lunch and then a presentation of Ruslan Serdorovich and then awarding the certificates. But given unfavorable weather for walking along slippery roads and since we are way behind the agenda, why don't we work without any break and listen to the presentation of Ruslan Serdorovich? Then we'll award the certificates, and after that we'll have lunch at Mr. Hotel. If you don't mind, then let me give the floor to Ruslan Serdorovich, and we'll talk about execution of the European Court judgments as to systemic and structural problems. Okay, let me share some thoughts on this issue. I didn't include everything in the questions when we discussed the presentation of Mr. Lishina as to the issues on the way of execution. On illustration, just one element to add, how failure to honor the obligations undertaken by the state has negative effects. Coalition agreement concluded at the end of 2014 had structural reform of all public authorities. Some authorities were reformed, but generally structural reform was a failure. you can say that it was the only reason for the respective judgment of the European Court, but we can say that failure to honor the obligations undertaken from the outset doesn't lead to negative effects that we are talking about today. I have prepared two documents as to further institutional development of the Parliament when it comes to execution of European Court judgments and as to the problems on Burwich case, which is especially sensitive. Ivan raised quite right questions about setting up additional authority. What was the way forward to make changes? We can change form indefinitely, but until and when we have political understanding at the highest level as to the necessity of execution of all judgments of the European Court, not only with respect to Ukraine, but generally speaking, and the execution of the Convention, given its spirit, we won't have any results. In June 2017, through difficult communication in the Parliament, we've set up the Subcommittee on Execution of European Court judgments. That was the first time ever. Was there any point and need in setting up a specialized subcommittee? A week ago, we had a discussion on that in Strasbourg. In one of the expert opinions, the focus was on the following. Unless we have the specialized authority in the Parliament, there is a risk that if it is everybody that is in charge of this, in reality, nobody would take care of that. What I saw in the Parliament when subcommittee was set up, it's the following. The understanding among the politicians of the existence of the problem and B, the necessity of addressing this issue was virtually non-existent. And that's the first or the crucial challenge that we need to cope with. So the highest political elite should realize that judgments should be enforced. And if the government says, the authorities say that they care about human rights, so that's exactly what the convention is about. And enforcement of the convention should be the primary task of any government. Fortunately, Subcommittee on European Court Judgments execution of the 9th Convocation was preserved, and though that's really minimum victory, but that's a victory anyways, because A, there is a specific person in the Ukrainian parliament in charge of this issue, and B, we show to our Western partners, including in the Council of Europe as well, that political authorities recognize this problem and necessity of resolving it. And a week ago, we had a very good meeting in Strasbourg with Council of Europe representatives and Parliamentary Assembly of the Council of Europe representatives. Why do we need the subcommittee on execution of the European Court judgments in Ukrainian Parliament? I believe that it should be strengthened and its institutional capacity on two areas. The first is execution of European Court judgments at the level of Parliament, control over the execution at the level of lawmaking of the measures of general nature, and parliamentary supervision over the government agent over the execution of the European Court judgments. Whether that's deputy minister or separate authority, it doesn't matter. What is meant here is that that's the way for the parliament to exercise control over the government on the execution of the European Court judgments. Second block to enhance institutional capacity is necessary to control by the subcommittee legislative initiatives as to protection of human rights through implementation of this law through the case law of the European Court, not only with respect of Ukraine. If European Court stated that through these actions the articles of the convention are violated with respect to other countries, then the convention in Ukraine is implemented in the same manner. We need to introduce filters not to allow to deepening and aggravating systemic violations and or attempts to eliminate this in effective manner. In the Parliament of the 8th Convocation, there was a draft law to execute Yamin judgment. That's ban on strikes and rallies. Liquidation of ban was discussed on the one hand. On the other hand, there was a chance for the government to make respective decisions that would allow banning the strikes. On the one hand, we are addressing the issue, resolving it. On the other, we exacerbate it from a different angle. The subcommittee should supervise over that. And another thing is if there are circumstances, then the subcommittee should point out that this provision may result in violation of human rights, given the case law of the European Court with respect to all Council of Europe member states. For instance, in the Parliament of the 8th Convocation, there were 2 draft laws as to peaceful assembly. Right. What are the alternatives? In our subcommittee, we've analyzed both draft laws, given the case law of the European Court on all member states, and came to the conclusion that Legal Policy and Justice Committee cannot be recommended to consider them, since they are in conflict with the established case law of the European Court of Human Rights. For you to understand why it is so necessary, let me say that the Parliament on Legal Policy and Justice, in the parliaments of all convocations, this committee has the subcommittee on constitutionality. Every draft law that is submitted to the Parliament is to go through the subcommittee as to its compliance with the Constitution of Ukraine. My position is simple. Article 22 of the Constitution of Ukraine says that rights of an individual established by the Constitution are not exhaustive. Article 9 establishes a mandatory effect of international treaty and their mandatory nature if they were ratified by the Parliament. Since European Convention is an extension or expansion of Article 22 of the Constitution, these 2 things, constitutionality of the draft law and its compliance with the European Court case law, that's guarantees under the Convention. So these are 2 elements of one thing. So as to paragraph 1 that I said, supervision over the government agent authorized to execute European Court judgments. To perform this, I suggested reducing legislative amendments to provide for regular reporting of the agent before the Parliament, as well as reporting of the committee and subcommittee as to execution. That's both individual and general measures, and fair satisfaction payment, and informing and developing joint strategy as to the further steps of the state. Nobody bans any kind of discussions, but unfortunately, in our country, if respective authority is not mandated to do something, so they are not vested with this imperative duty, then it works on a voluntary principle, or the principle of personal contacts. here we are talking about developing institutional capacity. So the development of joint action plan of the Parliament and government as to priority and time frame of execution of general measures for the support of lawmaking activity of entities, including the government, to adopt respective decisions to realize the approved action plan. So we are talking about the action plan that does not exist at the moment. There are some measures of general nature as to Ukraine, but the government doesn't have a strategy as to priorities of the general measures that should be dealt with first. I'm not saying that we should say that some human rights are much more important, some are less important. No, but if you say that we need to draw a line and properly communicate with the Cameroon and the Council of Europe, the Committee of Ministers of the Council of Europe and the Council of Europe, generally speaking, if that's, for instance, Ivanov and Bullrich cases, if you have the proper action plan and communication internal and external will get benefits. For instance, Vyacheslav Tymoshenko judgment is easily to deal with. As to torture, there are things that can be done easily, and there are things that require construction of new temporary custodial facilities or prisons that require a longer period of implementation and lots of money to be appropriated for the budget. But you need to set the priorities, what should be done this year or next year, and respectively, we need to develop our budget policy, because when it comes to budget policy, as to providing necessary financial and other resources to execute European Court judgments, both individual and general measures, and fair satisfaction, while there is no such policy on that. There is a 40/40 program. So some payments are made, some are not, but it's not strategy. It's not even tactics. It seems to me that it is important that this subcommittee engages judiciary to develop joint strategy and analyze the root causes for systemic violation of human rights, and in participation of judiciary developing the strategy of the further action plan for the state. It covers also development of legislative amendments to strengthen judicial supervision or control. And much is said about that, where the judge is to take care of the judgment until executed. Rather than deliver the judgment, it becomes final, and then nobody knows what happens to the judgment. If the judge is a conscientious person, then that's one thing. But if he's not, then nobody can complain against that. Through implementation of these things, we will develop respective draft laws and will allocate public funds for the execution of European court judgments. And that's important to have positive dynamics. I haven't analyzed the budget of 2020 on this, but previously we had only 500 million hryvnia in the budget. 600. Well, but the difference is huge.
It is a big difference even for those 12,148 applicants. And when we started analyzing the state with execution, the judgments of the national courts on the so-called social cases, there are about 200,000. This is the guaranteed figure, and actually the statistics even may be bigger. Talking about the point to execution, to entrust the subcommittee on its activities and legal policy with the powers to check every draft law for its correspondence with the case law of the European Court. And I support the point which was raised one of the people's deputies of Ukraine, that it's really important to analyze the draft laws not only on the stage of the first reading, because sometimes they may be creatively changed to the second reading. And if there is no violation of the convention at the first reading stage, it does not guarantee that certain things will not appear during the second stage. Talking about substantiation of necessity, according to the Article 22 of the Constitution, the rights are enshrined in the Constitution. The Article 9 of the Constitution states that there are international agreements and they are compatible with the domestic laws, and the Convention ratified just enlarges Article 22. Here it is important to understand the context within which the political bodies of Ukraine exist. The problem of populism is not only a Ukrainian feature, but unfortunately Ukraine lacks institutional filters to work on this populism. One more practical example. In the Supreme Council of the Eighth Convocation, the question was raised that the state guaranteed the participant of the anti-terrorist operation, which is actually war, the land plots. But this land plot should be given by the local self-governance bodies, and there is this certain legal algorithm that is known to all of us. Definitely the state probably should not entrust the local self-governance bodies with that task without, for example, indicating the sources for covering certain costs, but we have what we have. And there was the legislative initiative that, well, we cannot give the land to all those willing, therefore probably we should introduce financial compensation. So let it be the amount X. When I calculated the number of ATO veterans and the potential number of people who probably have the right to claim that compensation, so the sum was about 50 billion hryvnias. And the cases Ivanov and Burmich are just flowers in comparison with that amount. So there should be a body within the parliament that probably would filter such draft laws that pose a risk as ones that might potentially lead to systemic problems. And I would probably continue this parallel. Actually, in the government, there is such a filter. What about the quality of this filter? This may be discussed, but institutionally, this filter exists. This is the government agent on execution. This is Mr. Lishina, and he has to provide the opinion on every draft law that is prepared by the government and submitted to the parliament. But apart from the government, there are some other subjects of legislative initiatives, and there are lots of initiatives submitted by the members of the parliament. And sometimes it is not understandable what is behind a certain idea. Really, sometimes I'm under the impression that the person just made something up. Unfortunately, it is not funny. It is really tragic, because some of such initiatives later are transformed into laws, and really this is quite dangerous. What else I would like to mention? A couple of positions on further action plan when we talk about cases Ivanov and Burmich versus Ukraine, for us to have some positive dynamics. And it seems to me we can demonstrate this positive dynamics on condition of political will in the nearest future. The documents was prepared 1 month ago, therefore certain things should be updated already, but globally everything is more or less topical. For example, I'm talking about the budget 2020, but let it be the budget of the state. For example, the budget 2020 will definitely be sequestered. The Minister of Finance has already stated it, that there will be some changes. She is optimistic that the budget funds will grow. Let it be so. But for us to achieve some dynamics, in terms of payment, it's important because the court stated that you have to establish ad hoc procedure. You should plan some financial resources for the procedure, particularly in Burmich case. And 2 years that were given have already expired, have passed. Ukraine states, please give us some more time. But it seems to me for the European Court to make some concessions to us or to take our situation into account, well, here somebody stated that we just imitate execution of judgments. I would probably even go further and state that it is not even imitation, it is even far from imitation. And the second point, we have to introduce some amendments to the legislation of Ukraine, removing the existing collision between certain elements. For example, a couple of weeks ago, we discussed that law also in Strasbourg, and we have a very good law on execution of the court's judgments and application of the case law of the European Court of Human Rights. And the law provides its own understanding what is the judgment of the European Court. There is Convention 46, but we state, okay, that's okay, but we have our own interpretation of the judgment of the European Court of Human Rights. And the Ministry of Justice states that, for example, we have a problem. We cannot execute a Burmich case because Burmich is not the judgment of the European Court. When you start communicating these issues to Strasbourg, they do not understand what you are talking about. So probably it's necessary to use our common sense. During my political activity, I was thinking for a long period of time how we can explain to the non-legal people what is the rule of law, and I came to the conclusion that it can be the common sense. And when Ukrainian national law actually reduces the idea of the European Court of Human Rights judgments, there's something wrong. To prevent adoption of new laws that would presuppose some new moratoriums on execution of the court judgments. Here we talk about enhancement of the committee's capacity. The law of Ukraine should be recognized as one that lost its effect. This is about privatization of certain things which cannot be privatized. The ideology of the law is okay. This is about reducing the state part in the economy, so there are a couple of positive things. But at the end, there are a couple of fantastic statements, in brackets probably. These final statements ban to introduce the procedure of sanation and liquidation towards all the state enterprises, not only towards those which were part of the list, but it was about all state enterprises. So actually we were brought back the year 2001 when we had the law on the moratorium on execution, the court judgments on state enterprises. Sanation is introduced only about the defense-related enterprises. What should be done by the other state enterprises? They are almost bankrupt. The state is still responsible of them. We have the moratorium on 3 years. It is forbidden to take any legal actions with respect to such state enterprises, at least to those which are part of the list which cannot be privatized. And here we have a classical example where the subcommittee probably should raise its hand and state, okay, if we have to establish some restrictions or filters, let's take a targeted approach. Let's act in such a way not to enhance the problem of Ivanov and Brumich, to enhance the judicial control over execution of the judgments. We should talk about positive obligation of the state with respect to execution of court judgments. We can introduce changes and amendments to the procedural code, or also it is possible to be done by means of amending the documentation flow rules when the documents will be archived at a different stage than it is done now. At least the state judicial administration can assist us. And when we talk about changes to the procedural codes, probably will be helpful. When we developed the reform on execution of court judgments, when we had the new laws on enforcement of the court judgment, etc., the ideology which was used actually has not been changed since 2016 when these laws were adopted. So what we were talking about, that the judicial control should be enhanced and there should be changes to the procedural code of Ukraine in order to enhance judicial control and not to have this football between different institutions and organizations. Unfortunately, now it's in a sort of stagnation. It can be a debatable issue, but we have to respond to it. In my opinion, the thing that should be done now is making equal the mandates of private and state enforcers. This is not a fresh idea. This idea was discussed as far back as 2015 when we introduced the reform on enforcement of court judgments. We have the Bulgarian experience where they have this mixed form of enforcement of judgments where the state enforcers cannot work with the state enterprises, and it is done in order to avoid the conflict of interest. Just resuming trust to the job, to the profession of state enforcer. Now the Ministry of Justice actually gives us carte blanche in order to do it, and it should be done.
If you do that, that will result in the need of increase in private enforcement agents. When this form was introduced, we planned to have at least 1,000 private bailiffs by the end of the year. We have 200 of them only. So the percentage of decisions they receive to enforce is 1%. They are very effective, but 1% of the decisions they take care of can change the situation dramatically. So, and getting back to Ivanov and Burmich, it results in the case that the government is to be responsible for the obligations the government don't have to, because the bailiff was supposed to enforce the decision and the problem wouldn't exist. The next thing is introducing the system that would be working online, and at least it will allow to freeze bank accounts of the debtor or allow collecting debt. That's legislation that is needed here, as well as technical means, because we need to set up the software, identify who is going to administer it, change the architecture of bank supervision. But it's important to do. I saw how it works in Lithuania. If there is a judgment, enforcement should be easy. especially if debtor has funds, assets. Whether these are private bailiffs or we're going to stick to the mixed system, that's the communication to be done by the Ministry of Justice. But the system to execute judgments by the state authorities shouldn't require enforcement. In Bulgaria, when I ask them who executes decisions against the state, the answer was nobody. They are just enforced. Thank you for the presentation. Andrei is not here. Andrei Kostin is not here, unfortunately. We couldn't hear the comments of Mr. Lishina. He had to catch the plane. It was about the interests of the state representation that was covered by Mr. Sidorovich. I believe that your presentation will prompt the discussion. Paulo. Thank you for the presentation. When listening to you, I feel even more motivated to work further on enforcement of the European Court judgments. I think Ivan will listen to your presentation using the video. The meeting on the law of 2006. When the law was adopted, the model that was offered was copied from Human Rights Act of 1998, UK. And when the law was adopted in 2006, Parliamentary Assembly of the Council of Europe analyzed this law jointly with the UK Act and identified it as the best practice for the system. But in 2006, we didn't have the judgments as to systemic and structural problems, and the main being paying fair satisfaction and budgeting of fair satisfaction. So today, given what I was talking about, we have the law that should be amended to reflect the best practice of Parliamentary Assembly. At the meeting, we also spoke about the practice of the UK and the Netherlands with respective institutions there. They look not only at the practice of their respective countries, but at the practice of other countries as well. That was about model. With respect to resources, according to the Department for Execution, Ukraine, starting 2011, paid 50 million as a fair satisfaction. That's 1.3 trillion hryvnia. If you convert that into structural projects that could be implemented, that's another resource that could be used. This 50 million euro that was paid is not the full sum of money that covers full execution of judgments. That's execution of national judgments minus over 1,000 cases on Burmich, fair satisfaction multiplier by 12,000 euro at national court decisions, and add this to the sum I mentioned, plus obligations to execute national court judgments in other cases. And the last thing, indeed, and Ruslan can probably recommend something on that. The problem is not only to consolidate the positions of the state at the execution stage. It seems to me you mentioned that in your presentation. It seems to me there is a problem of the feedback here, because when the decision is made by the Committee of Ministers, when the action plan is considered, then this consolidated action plan of the government well, the National School of Judges participates in that. Do you see the report that the government sends to the Committee of Ministers? Have you ever seen the reports of the government sent to the Committee of Ministers? And do you see the decision of the Committee of Ministers later, following the collection of information that you requested? That's very important because you need to figure out what are the expectations of the Committee of Ministers and the Council of Europe. As to communication, why did I speak about enhancing the capacity of the subcommittee that could initiate and institutionalize this mandatory reporting? Because communication is missing. When I became in charge of this problem and set up the committee in June 2017, all the information was collected just thanks to my efforts, using my personal contacts with the Council of Europe and Ministry of Justice or other institutions. I went to the Supreme Court in different courts in different jurisdictions, but the idea was to collect information and to make it available to all stakeholders. That's what is missing at the moment, since neither the Parliament nor the Court and even the Cabinet of Ministers don't know what's going on when it comes to the execution of European Court judgments. When I started addressing Burmich case, I started torturing Ministry of Finance. It was Daniluk then. Ministry of Finance was not even aware of the problem and the need of addressing it. So low quality communication of internal nature at the end of the day leads to low quality of communication of the government agent with Strasbourg, because for his part he doesn't receive the sufficient information that he can provide to the Council of Europe to show what has been done, what is being done, what is going to be done. So that is linked to another problem that's given the law of 2006. We need to change this position. We don't have to change this position to realize the measures of general nature. We need to consolidate the efforts of all ministries. Not only the government agent won't be able to address that. Ministry of Justice on its own won't be able to do that because it involves Ministry of Finance, Ministry of Information Policy, or whatever its name is, Ministry of Social Policy, Pension Fund, Treasury, Ministry of Infrastructure, and a set of other institutions. So without a respective understanding of the problems at the highest political level, we can produce good documents, but they are not going to be working documents because there is no proper communication here. So that's why it is important to enhance institutional capacity of the subcommittee. Natalia. Natalia Kavalka, Associate Professor, Kiev National University, the President of the Association of Mediators. Interesting presentation. It's very comprehensive. Olga mentioned mediation. It is known that effective ADR in any country is the guarantee of the rule of law and access to justice. On Monday, in the subcommittee headed by Kostin, there will be the first meeting with participation of all stakeholders of the mediation community. We are going to discuss the draft law on mediation. Since you were a member of the parliament of the previous convocations, and given the systemic mistakes that were there and did not allow for the in the parliament to vote for the law 3665. What's your advice? What should be done or what shouldn't be done so that this new draft law on mediation is approved in our country, and mediation that has been working effectively will be working at a different level, and judges will understand that mediation is a support for the judges that will allow to decrease the workload for cases, and I'm sure it will decrease the workload on the European Court, because parties, as soon as they made decision in the course of mediation, take responsibility for that and they are able to enforce it. Thank you for the question. On the surface, it might sound short and simple, but it's very broad. In the Parliament of the 8th Convocation, this draft law was the hostage of bickering that had nothing to do with the draft law. Though, why was it difficult to approve it? That's quality of the draft law, to start with. And I pointed this out to the authors. It was based on the Canadian model, but it was a kind of, patchy and unsystemic approach. The architecture of courts in Canada is different, and you can't copy and paste this law. You had to adapt it. Secondly, for example, the draft law didn't have the following, for instance. It was contractual dispute. The parties came to agreement. What happens to the case? With proceedings, well, the proceedings were terminated for the time of mediation. So settlement was reached. What happens to the case? What the court should do? Close the case, or it should be left terminated. If it is left terminated, it can be forever, because again, the question here is, do we need any judicial control or not? What happens if the settlement is not executed? Should the person seek enforced execution, or reopen the proceedings, or submit the motion to perform the contract? What happens next? It was not covered by the draft law. You need to think through everything so that it is not a stillborn child. It's a very good idea, but if we speak about decreasing the workload of the European Court of Human Rights, then this draft law, I'm not sure that it will resolve this issue, because the state mediation that should be done by the respective authority, well, it can be done by attracting mediators as well, but mediation procedure, when it is about reconciliation of the parties at the stage when the communication is just established with the country, or even before that, it should look adequate. And another important systemic problem that needs to be addressed, though it covers all issues, not only the execution of European court judgments. That's the following. Every official has the position, it's better to do nothing because I'm not going to be punished for that. Because if I do something and will be proactive, then I can be charged with corruption offenses. So we need to change the paradigm of the attitude to potential corruption risks and provide the necessary discretionary powers to incentivize the officials. I have more than 20 years of attorney experience, and I been mediator a couple of times. But mediator is successful when he has the discretion to make decisions and communicate with the parties. If that's a state position, so he has like hundreds of different documents to collect from different authorities. Mediator doesn't make decisions. It helps. He's a mediator, but he doesn't make the decision, but he should encourage to the decision to make sure that the parties find it. If he doesn't know how to find it, then what's his value? Let's say Burmich cases. The problem we are facing, how to find settlement with people so that they don't go to the European Court. So you have to have the goal in mind in the mediation procedure. And the mediation, given the European Court problems, is different from any other judgments. Thank you. Any other questions? Thank you, Ruslan, for your presentation. You mentioned judiciary, and you said that the judges should be responsible partly for the execution as well. And that's a painful issue. I am in charge of the judicial control over the execution in administrative proceedings. That's around 7 or 8 years when I have been dealing with that. Well, nobody needs that. Well, that's the most important thing. And the court visitors, those people who need it, they are the only one who need it. Lawmaker doesn't use the potential that judiciary have amassed. There is no bank of ideas. In the course of discussing execution of judgments, I realized the following. In the state, there is no diagnostic center that would tell where the debt comes from. Look, I am a judge of administrative justice. I have groups of cases that I know that I will go to the European Court, and then the executive authorities will have to make sure that the judgments are enforced. But the disease is pretty clear, and that's seen through the courts of all instances. But until this case reaches the Strasbourg, other branches of power don't want to notice it. So to execute judgments, we need political will. That's the most important thing. Then realization by all branches of power that this is not the problem of specific director or enterprise, but that's the problem of the state. If it is realized on the level of the state, and there is understanding that there should be a thorough work to make sure that the judgments are executed. Thank you for the comment. You have advantageous position because administrative court, contrary to other codes, has some tools of control. If you talk about commercial and civil process, then unless the judge refers the case to archive, he'll get punished because there is a time frame for that. And the assistant should collect all documents and make a file out of it. When executive writ is issued, so the judgment is submitted for execution, and there is a complaint, so it is the judge who delivered the decision that is to handle the complaint. And so he requests the case from the archive again. That's absurdity. As to some of the cases to go to European Court, that's an interesting problem, how the executive authorities take their positive obligations before the citizens and abuse their procedural rights. Two examples on that. That's about Article 13, excess of length.
The first example, probably you remember that the tax bodies didn't pay the court fees. When they were obliged to pay the court fee, they came to the Cabinet of Ministers and said, please give us 10 billion hryvnias to pay the court fees. They were given a bit less than 1 billion. In 2017 it was. I do not have some further statistics. And they have used about 700 million. What I'm trying to say is actually our state is involved in too many legal proceedings with the citizens. It's much easier for our officials to reject certain things. The person goes to the court, then the judgment of the court is given, the judgment is given to you, you do not enforce it, and then the citizen goes to the European Court of Human Rights. In 2015, there were certain amendments which actually wanted to liquidate the simplified system for some social categories. And I told at the time to the Vice Prime Minister that the administrative justice will have some serious problems. I just asked him, don't you want to pay? And he said, yes. Actually, the executive bodies in Ukraine are trying to find some ways how to just cover up the problem for the time being until they are in power and let the just next officials deal with it. So these are two good, bright examples where actually the executive power is not trying to address the problems, but is trying to actually enhance it. I'm happy to welcome you here. It's really good you came. And I fully agree with the statement about execution, the judgments of the European Court. And actually, with respect of human rights, we do not have good communication between the state bodies. I fully support the ideas that we should probably adopt a doctrine or a concept or guarantees of the development of the state. What is happening right now? For 5 years, our state is trying to reduce the functions of the prosecutor's office, including the powers related to pre-trial investigation. Now we have change of power, and we have new amendments to the Criminal Procedural Code of Ukraine, and the functions have been broadened. And the same situation is in some other fields. And I think that lots of those present here probably even do not know that the national strategy in the field of human rights already exists. It was adopted by the President in 2015, and there is even an action plan on its implementation signed by Mr. Yatsenyuk in 2015. And the strategy is for 2015-2020, but the level of its implementation, according to our estimate, is about 20%. And there are several reasons for these, both the formulation and the fact that actually the very strategy is signed by the head of presidential administration, Mr. Loshkin. There were a number of events organized for implementation of the strategies, but I have always stated that without participation of the member of parliament, it is impossible to implement it 100%. And actually, it happened so. There were problems when we discussed the issues of social partnership. Somebody has written that the point should be adopted. The Ministry of Justice started thinking about it, started implementing this point into action plan, then not. I'm listening to 3 channels, let's say your own, I'm hearing you, and I have some other people talking. So dear audience, please respect the speaker and listen to the comment. Certainly, development of the strategy, which would include the issue of execution of the European Court judgments, is an important case. We are ready to participate and to contribute to this good thing. A brief answer. It's very important to have strategic vision. Tactic and strategy is also important. Without strategy, all the other actions will be chaotic. So the new government should not start from scratch. There are enough both domestic and international experts that have been working for a number of years. And now we have to bring the elaborations together and start implementing it. The biggest problem, unfortunately, in Ukraine is that sometimes we prepare quite good documents. What is problematic is the implementation. Sometimes we even pass very good laws, but again, the problem is with following the laws. For example, the law on people who are responsible for executing the judgments is good, but if the implementation of the law really was good, probably the judgment in the case judgment mentioned others versus Ukraine probably would not exist. Natalia actually recommends me that we have to wind up this session. Thank you very much, Ruslan, for your presentation. And now I would like to get to the final traditional part of our event, of our forum. This is a certificate award ceremony to the participants of the forum. But before doing this, I would like probably ask the participants whether somebody has some reflections on the forum. Probably you would like to share these reflections, or probably you just would like to express your opinion. Do you? Please, the mic. I would like to sum up our event, to sum up our platform and forum. We all have the right to a healthy lifestyle, and therefore it should be guaranteed. Therefore, I probably will be brief. Good afternoon, dear ladies and gentlemen. Once again, you know me. I'm a vice rector of the National School of Judges of Ukraine. My name is Natalia Shuklina. The National School of Judges of Ukraine is the co-organizer of this forum, and today is already the 8th forum. So, dear ladies and gentlemen, dear excellencies, dear judges, this is the end of our 8th International Forum on case law of the European Court of Human Rights, which is dedicated to the very important questions, which is the right to a fair trial. We have all paid attention to this great atmosphere we have had throughout these 2 days. The forum has always been constructive and active, but now we have a professionally friendly atmosphere about our forum. And the question is, why do we have this atmosphere? We have all the time discussed very important issues. We have all the time invited the European judges, the judges of the European Court of Human Rights. So what is the secret of this particular forum? First of all, I would like to express our gratitude to Ilya and his support his project, support to the implementation of the judicial reform in Ukraine, for a very thorough approach to the agenda of this forum. So you really have chosen great topics and great speakers. Ukraine and its judicial system now are had some difficult position. You all know about the law 1008. We know what kind of risks it poses if it is implemented. And what I was really touched with is the fact that the questions raised today were highly topical, and as Lenin said, they were of major importance for the state and for all of us. The second point I was impressed with is the openness and sincerity in the process of discussion. And I really was happy to see here the judges from the European Court of Human Rights, and I'm really grateful to our distinguished judge, Hanna Jutkivska, who in my opinion is one of the wisest judges in the European Court of Human Rights. The second point, today we have heard the genius of the theory, yesterday we have heard the genius of the theory of law, Mr. Petro Rabanovich. We heard Mr. Mykola Hnatovsky, who is the head of the Committee on Preventing Tortures. We also heard the judges from the Supreme Court of Ukraine, who were really very knowledgeable in terms of their professional level, and they were really on the level with their European colleagues, and we really appreciated their deep both theoretical and practical professional knowledge. So we can be really proud of our judges. And also I would like to thank you, dear participants of the forum, because you are our audience. You really competed for participating in this 8th forum, and in your discussions, in your debates with highly distinguished speakers, you have shown also very high professional level. So we are really proud of having here the students of Kyiv National University, named after Taras Shevchenko. We have here the students from Ivan Franko University. We have here our distinguished colleagues from Odessa and many other cities of Ukraine. You are the future of Ukraine, and it is in your hands that is our future. So please participate in such platforms, participate in such forums. I have been working for many years at the law faculty of Kyiv National University. I have spent half of my life there, but I really liked what we have had here. I all the time was interested in what you were saying, and I'm really proud of you, and I hope our country is proud of you. And as our moderator stated, this was quite a complicated work of him, because really we have talked a lot, and he was really very good moderator. He gave us a chance to speak. He created a great platform for professional discussion, because we are trying to create our own judicial policy for our state. Thank you very much on behalf of all the participants for this highly professional program and for great moderation of the event. I also would like to thank Mrs. Natalia Vereshinska, who is the logistics manager, who was responsible for the logistics of the forum. We have made these 2 days, and as Mr. Chernohorenko has said, now we are going to have the most pleasant part. This is certificate award ceremony, and these certificates really prove that you participated in this highly professional forum. Thank you for your attention. Probably we'll do it together with Pavlo, because he is representing the Council of Europe, the European Court on Human Rights, and he is a distinguished person in Ukraine.
Let me thank everybody for organizing this event. Let me thank all of you to make it happen for us to stay for today's here in symbolic premises for the human rights activists. And tomorrow we'll start thinking how make our life even more interesting. And that's going to be preparation for the 9th International Forum on the European Court Case Law. Let me wish all of you health, stay inspired in your professional work, accomplish what you planned, and enjoy your professional life. On behalf of the Law Department, let me thank all participants of this forum. We did enjoy this 8th forum. Each of us got enriched with knowledge, experience, and new contacts. And let me thank the OSCE and Council of Europe projects. We are looking forward to further cooperation. And starting Monday, we'll get ready for the next international forum.